17 for audios.
Hello, it may be taken after some time. My senior is on legs.
Item 80.
Make the mention. In this case, service complete and TCR also received, Lordship.
In this case, I am for respondent for one. In fact, prohibition quickly, we have student notice to them asking for instruction, but we have not. So we are likely to withdraw from this case, but one opportunity may be given.
Okay. So you want to withdraw from this case?
From the case, but one opportunity may be given, so that we can last attempt can.
Ms. R. Sodori, learned counsel for the appellant, and Mr. Your name, please?
RK Sharma on behalf of the Chaudhary.
R.K. Sharma, learned counsel, appearing on behalf of the children, learned counsel for the respondent. The learned counsel for the respondent submits that he want to withdraw this case, withdraw from this case, and also he has issued a notice to the respondent, and he further submits that he may be granted another opportunity to receive the instruction. Parallel, this is the matter immediately after reopening of the petition.
Item 90.
Lordship, any date? And Lordship, there is an IA 2391, there is a status quo granted, Lordship. That may kindly be continued. 2391, Lordship.
You keep this notice with him.
আপনার তো লই লও যদি আগে ফাইল করে আপনাকে লাগিব না কাগজখন লই লও
In IA, heard me so and so, learned counsel for the applicant and the respondent. Interim order passed earlier, dated 23rd 8 2020, shall continue. 2023 shall continue.
obliged.
Item 90.
As per office note dated 20, I am for the petitioner.
Hmm.
Office note dated 27/3/26, LCS is already been received. Service is complete. Let the matter may come for admission hearing.
Maybe fixed for admission hearing. So Borboya, you are appearing here.
I am applying for number 2, 6, 1, 6, 2, 6, 3, 2 and 6, 6, 1, 6, 2, 6, 3.
Heard, Mr. Your name, please?
T.
T. Roy, learned counsel for the appellant, and Mr. F. U. Borboya, learned counsel for the respondent number 2, within bracket 6, 1, 6, 2 and 6, 3. The learned counsel for the petitioner service that in this matter service has been completed and the matter may be listed for admission hearing. Accordingly, it is provided that recessal list the matter for admission hearing on cover fixed.
27 full.
Sort that. Whole matter.
Much of it.
Item number 20. Service completed.
We have a clear finding the covenant under recently.
Okay.
For the sole response.
Chairman, not LCR may be called for because the thing is that order 9 rule 13, a petition was there and that was passed ex parte. So ex parte is
We will call for the scan copy of the record.
Madam,
Scan copy.
scan the.
Heard, Mr. Tokon, learned counsel for the petitioner, Mr. Bhakti for the respondent. It appears that service in this matter has already been completed. And as such, recessal is the matter for admission hearing on cover fixed date
6th May.
6th of May. In the meantime, recessal call for the scan copy of the record from the learned trial court. Immediately.
Obliged. Which one?
But in this matter, when I am appearing on behalf of the respondent number 1 to 6, regarding respondent number 7, madam, but he already died on 31, 25/10/2018. So perhaps even before filing of the first settlement.
So legal heirs are to be impleted?
No, my lord, he died before filing of the first settlement. So perhaps, my lord, the judgment against her is confirmed, my lord, because
Okay, okay. Heard, Mr. Setia,
My lord.
learned counsel for the appellant, and Mr. S. Das, learned counsel for the respondent number 1 to 6. Mr. Das submits that respondent number 7. Srimati, what is the name? Simon Nessa. Simon Nessa suffered demise before filing of the appeal before the learned first appellate court. First appellate court. First appellate court. First appellate court.
my lord, this appeal was filed on 12/1/2018 for appeal. And she died on 25/10/2018. So during the pendency of the first appeal, itself.
Okay. During the pendency of the first appeal, the respondent number 7 suffered demise. So what to do? You want to proceed against her?
So, my lord, I have to file the substitution petition, my lord.
First, you obtain instruction then. Mr. Setia, learned counsel for the appellant submits that he may be granted some time to obtain instruction in respect of proceeding against the respondent number 7. Pair allowed recessal list the matter immediately after reopening of the vacation.
I do.
Lordship,
the engaged counsel for the respondent Mr. G. Swami is unable to take the matter to the clerkship. He has some personal difficulties, Lordship.
None appears for the petitioner on call. However, Miss
A. Sharma.
A.
A. Sharma.
A. Sharma, learned counsel appearing on behalf of Mr. D. Goswami, learned conducting counsel for the respondent submits that Mr. Goswami has some difficulties today. And as such, he prays for listing the matter after 1 week or 2 weeks.
1 and 3 to 8, 10 and 11.
Recessal list the matter immediately after reopening of the vacation. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Family item 17, water method.
Maybe, Lordship. My lord, in earlier occasion, your lordship desired to know whether the earlier order, where it was stated by the Honorable High Court that their services should be deemed to be provincialized, whether out of those two orders which we were annexed, we had annexed in our writ petition, any person has been appointed or not. My lord, after hard labor, my learned friend was directed to produce, but they did not. But we have collected one copy of that order out of these two. We have filed page 97. Here, this person, Shailendra Kumar, petition. Shailendra Nath Sharma was appointed and he filed the writ petition. That writ petition may be seen page 64 of the writ petition.
Yes.
For a moment, Lordship, kindly see page 64 of the writ petition. Here, Shailendranath Sharma filed writ petition. And now kindly see page 69, madam. Order of the Honorable High Court, operative portion I am reading. Para 9. I have gone through the contents of section 3 and 4 of the Act of 2011 and also gone through the contents of section 24 of the Act of 2011. I have also gone through the judgment passed in review petition number so-and-so and judgment dated so-and-so of this court passed in WPC number so-and-so, considering the facts and circumstances of the case of the petitioner in WPC number so-and-so, the case of the petitioner in this case, I find that facts and circumstances of two cases are quite similar. Considering the provisions of section 4 of the Act of 2011 and judgment passed in review petition number so-and-so, I am in total agreement with the judgment passed by the coordinate bench dated so-and-so in WPC number so-and-so. Therefore, I am of the considered view that the petitioner should be deemed to have been provincialized on the day the other employees were provincialized. Hence, the writ petition is allowed and the respondents are directed to issue necessary orders within a period of 2 months from the date of receipt of the copy of this order. Now, Lordship, kindly see page 97. This is the follow-up order passed by the government. This person has been appointed by the government. That is page 97. And our case, regarding our case, my lord, the DO has admitted. For a moment, Lordship, kindly see page 37 of the writ petition.
Hmm.
37, my lord. From so-and-so District Elementary Education Officer Dhubri to the Director Elementary Education Assam. With reference to the subject stated above, I have the honor to inform you that the District Scrutiny Committee observed that earlier the name of Mughal Hussain, assistant teacher, was recommended by the District Scrutiny Committee through oversight. The actual name should be Anjuara Khatun, a assistant teacher instead of Mughal Hussain, assistant teacher in Uttar Gunimari VLP School under Bilashipara Education Block. Hence, the District Scrutiny Committee resolved to request the D Assam for cancellation of the recommendation of Mughal Hussain, assistant teacher, and requested to issue service provincialization order against Anjuara Khatun. So, Anjuara Khatun is a petitioner here. So, that was sent to the director, but the director has not passed any follow-up order. That is page 39. That order is not sufficient for us. I did not get any good result from the government. Page 39. It is again sent by the director to the government, and in this way, my lord, interdepartmental communications are going on. But in case of Shailendranath Sharma, who is similarly situated person, out of 2 persons who were appointed, but one we could collect, and that is we have annexed through additional affidavit. That is page 97. And Mughal Hussain, my lord, he is an imaginary person. Actually, I don't know how the DLC recommended his name. However, the DLC has admitted their guilt that yes, that was sent due to mistake. And that was conveyed to the DO, and DO.
They have adopted any resolution to that effect.
My lord?
Whether they have adopted any resolution to that effect.
Yes, it appears from the DS letter. Here, my lord, if 37, kindly see again. That the District Scrutiny Committee, second line of the letter, observed that earlier the name of Mughal Hussain, assistant teacher, was recommended by the District Scrutiny Committee through oversight. The actual name should be Anjuara Khatun, assistant teacher, instead of Mughal Hussain, assistant teacher, in Uttar Gunimari village level LP School, Hansel LP School, under Bilashabar Education Block. Hence, the District Scrutiny Committee dissolved to request the D Assam for, so they took resolution, madam. It appears so from the order. And this Anjara Khatun, my lord, she was appointed on 15/7/2004, page 26. So considering the latest situation and considering these similarly situated persons filed writ petitions and their petitions were directed to be considered and deemed to be provincialized, and that order has been given black and white color. We have annexed, kindly similar relief may be also provided to me.
Yes, Mr. Fukun.
Lordship, we have filed an affidavit on my lord, 5th of January 2026, my lord. I would like to, my lord, Lordship, take Lordship to the affidavit again, my lord. Because that will be crucial for the proper adjudication of the case. My lord, first thing first, my lord, is that I would like to showcase, the my lord kindly comes to page. The affidavit of- filed by me, my lord. Page 78 of the affidavit of opposition. There, my lord,
Paragraph number?
paragraph number, my lord, from 5, paragraph 5. Here, my lord, Philosophy states that the committee, that in compliance of the aforesaid honorable court order, the proposal of provincialization of services of the petitioner, paragraph 7, my lord. The state level scrutiny committee meeting held on 7/24. The committee reviewed the case and found that the petitioner does not fulfill the DIAS criteria, as her name is not found in the DIAS code till so and so, my lord. Therefore, the SLSC decided to reject her claim for provincialization of services and authorize the respondent number 2 to issue order. Then pursuant to that, my lord, SLSC's decision, my lord, respondent number 2 issued the seeking order dated so and so, rejecting the claim of the petitioner for provincialization of services as per the Act of 70. The petitioner, my lord, thereafter, my lord, now has filed another petition so and so 6968, my lord, wherein the honorable court by order dated so and so directed the standing council for elementary education shall obtain instruction as to whether the petitioners is so and so and so and so were appointed by the state in compliance with the direction, my lord, in those writ petition, and if they have been appointed by the state, then the appointment letter shall be produced before the next date. Now, my lord, will come to paragraph 9, which is crucial. Here we have given the reason, my lord, that first of all, the appointments which have been we have shown, one is of secondary education, my lord, and the other is of higher. Now here it is seen that, my lord, 3499 of 2014, which he has mentioned, pertains to the directorate of secondary education, my lord. We are elementary education. And WPC 6804 is of 2017, my lord, pertains to the directorate of higher education, my lord. That is totally different, separate. Then, my lord, further it is to be mentioned that the DIAS data of elementary school was maintained from 2006 and 2007, and accordingly, provincialization of services is done as per DIAS conditions under 2007 Act 17 Act. That means, my lord, this Act 17 Act, this 17 Act applies in our case. Secondary education is separate act, and even higher education separate act. That will not apply to us. There, my lord. Therefore, my lord. Now your lordship comes, my lord. Therefore, after that, my lord, for provincial elections and secondary separate parameters are used. On the other hand, educational institutions under higher education is yet to be maintained. The higher spirit matter is not similar with secondary education as well as higher education institutions with the institution of elementary education. Another particular factor, my lord, which has to be taken into consideration is that the appointment order petitioners in WPC 3499 of 14 and 6804 are not issued by our directorate, my lord. It is not issued by the directorate of elementary. Further, on perusal of the records, my lord, the name of Moghul Hussain is found in the diocese. So, my lord, again, if your lordship comes to book, my lord, 79, the DIAS data has to be, we have to follow the elementary education, has to follow the DIAS data, my lord, which is given. Kindly come to, my lord, page 103 of the book, my lord, 103 of the 79. It is definition to I, to small Roman I. That shows, my lord, the DIAS code. The district
এখানে
information
বলতে
system for
পারে
education.
16 and 17 এটা এখানে
As available in the records of the National
16.
University of Education Planning and Administration. So in this guy's data, his name has to be, her name has to be there. So now as per our records method, the name of Mogul Hussain is found to be there in the guy's data against the petitioner. School from 2010 to 11, 2015 to 16. That is during provincialization as per Act of 2011, during 13 and thereafter. On the other hand, my lord, the name of the petitioner was found. My lord, it was-
19
name of the petitioner was found in the year 2016-17. We will annex it in the appendix. 2015 and 17, her name was found, my lord, after 3 years of provincialization of the school, my lord. That is to 2013. my lord. After 3 years. So now, my lord, I would like to again come back. It is pertinent to note that
তোকে দিলে
that name should have appeared in the dias data as she claimed to have joined in the year 18/7/2004. So she is claiming, my lord, that she was working from 18/7/2004. But in the records, her name is showing from 16/17 proper. So that means, as per rule, my lord, again, your lordship comes to rule 4, which will come to page 114 of the book. 114. 114 of the book, my lord, which is section 4, my lord. 114.
Yes.
114 is, my lord, teachers and or tutors to be government service. Subject to fulfillment, my lord. Subject to fulfillment of all other provisions of this act. The services of teachers and tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Why not, we are concerned with 4.3. 4.3 says that must have rendered at least 6 years continuous service. As
Okay.
on 1/1/2017, from the date of joining in the venture education institution, which must be on, this is crucial, 31/12/2010 or prior to that date. So if if her appointment, my lord, as per our records, is from 2016, her name is found only in 16/17 data. We annexed it here, my lord, in the annexure. So how can she claim with the other thing, my lord, other? And my lord, that judgment which the learned council has produced, my lord, in the additional affidavit, there 4.1 has only mentioned, my lord. It's true, my lord. It has been mentioned. If a lordship comes to this the same section, my lord, has been mentioned. I think it was order. But it is comes to writ petition, my lord, he has annexed the order. My lord. Swailendra Sharma, my lord. Swailendra Sharma, I think at page 64. That's at page 64. Paragraph 2, my lord. Here also the same thing is mentioned, my lord. In the year 2011, in the year 2011, the government of Assam passed, my lord, two, my lord, with
2011
the part which is, my lord, asterisk, my lord. In the year 2011, the government of Assam passed Act of Venture Education Institution. Under section 3 and 4 of the Act of Venture Schools or private venture, my lord, at least 7 years of imparting education from the date of affiliation, my lord. 7 years. Can you note that part? And my lord, will kindly come to the last part, my lord. The page 67 of the, my lord. Seven years has to be there, my lord. Paragraph 9. I've gone through the contents of section 4 and 3 of section 4. So, my lord, if that person is prior to 2010, as per the 17 Act, my lord, then he can mistake, but his name is not there. And your lordship will come to annexure.
এটাতে কোনো এল কিছু লেগে তাহলে বলে কথা বলছে
It will not only have this secondary short.
Come to annexure to page 85 of the affidavit of authorized.
সেকশন
Yes.
Yes.
Annexure to Yes, my lord. Your lordship, kindly see the remark column. And it's page 82, remark column. The school is identified as newly provincialized school in years 16-17. And her name is there, Anjumara Khatun. Lordship, see the name of the teacher, Anjumara Khatun, the petitioner, and her name is shown in 16-17. That in the remarks column.
Chairman.
So therefore, my lord, again we come back to page 80, my lord, up from 85, my lord. The paragraph, my lord, which I have given, that after 3 years of provincialization of my lord, 16-17, on the other hand, the name of the petitioner was found to appear in 2016-17 after 3 years of provincialization of school during 2013. It is pertinent to note that her name should have appeared in the dias code earlier, as she has claimed to have joined the school on 2000 since 18th of July 2004, as per the petition. Therefore, the matter is of inadvertent mistake and is doubtful. Another pertinent issue that needs to be pointed out is that permanent retention of posts provincialized in 2013 has been issued by the government only against posts which are held by incumbents, and all vacant posts have been abolished, lordship. All vacant posts have been abolished if there were any vacant posts. And so the vacant post of the petitioner school is abolished, my lord. There was a vacant post, my lord, initially. If your lordship comes to annexure 1, page 84, at that point of time, when Abdul Rashid was provincialized, there was one post vacant, my lord. Page 84. Which is category wise number of posts and name of working incumbents. There was one post vacant at that point of time, before prior to this thing. And which Abdul Rashid is there and the other post is vacant, my lord. So therefore, my lord, my humble submission, my lord, this petition, my lord, should be dismissed, my lord, in the and my lord, in the context of section 4(1), since as per my lord, as per 4(1) of the 17 Act, the new Act, had she been working prior to my lord 2010. More specifically, the date my lord mentioned is 31st December 12, 2010, my lord. And my lord, the orders which council has shown, my lord, specifically regarding in the additional affidavit, the order that is, my lord, passed by a separate directorate, my lord, having a separate rule, my lord. And also the other case, my lord, where the higher education department, they have shown that both the rules are different. The parameters of appointing and recruitment are different, my lord. In our case, 17, the Act of 17 will apply. So in my lord, looking into that aspect, my lord, I therefore pray that, my lord, the petition may be dismissed, my lord.
My lord, first my learned friend has said that this 2011 Act creating LP school, etc., but actually that is not correct, my lord. It even reached up to college level. For instance, lordship may kindly see section 2, section 2 of the 2011 Act. Lordship would say here, Assam Higher Secondary in this Act, unless the context otherwise requires, Assam Higher Secondary Education Council or Assam Higher Secondary Education Council means the Assam Higher Secondary Education Council constituted under the provisions of Assam Higher Secondary Education Act. Assam Higher Secondary is coming here.
What is the page number of your book?
Page 648, madam. 648, the Assam Venture Educational Institutions Provincialization of Services Act 2011. Kindly see section 2. First, it is stated that Assam Higher Secondary Education Council or Assam Higher Secondary Education Council means the Assam Higher Secondary Education Council constituted under the provisions of Assam Higher Secondary Education Act 1984. So higher secondary school is coming within the purview of this act. Now, Lordship may kindly see page 650. P. Section 2P. Fencer High School means high school including a high madrasa imparting education up to class 10 and established by the people of the locality. So, and then Lordship would say Q. Fencer Higher Secondary School means a higher secondary school imparting education up to class 12. Then kindly say 2S. 2S, Fencer Primary School means a primary school. So
Okay,
here,
Okay, all right. Okay.
so it covers all the schools, even up to college level. Wait, just wait for some time. Now, Lordship, kindly have a look to page 43 of our petition. Whether the learned government advocate can submit something which is their officer is saying otherwise, kindly see page 43. To the Director of Elementary Education, Assam, regarding provincialization of service of Anjuara Khatun as assistant teacher of Uttar Ghunimari LP School under D.O. Dhubri. In inviting a reference to the above, I am directed to state that the Uttar Ghunimari LP School under D.O. Dhubri not provincialized with 2 posts of assistant teacher by showing 1 post vacant, by your order number so-and-so, dated so-and-so, as per records furnished from your end, by letter under reference, it appears that due to oversight, the district level scrutiny committee originally recommended a wrong name in place of Anjuara Khatun. Subsequently, the district level scrutiny committee rectified the mistake and recommended the name of Anjuara Khatun for provincialization as assistant teacher of Uttar Ghunimari LP School, while the proposal for provincialization of services of Anjuara Khatun was under process. The Honorable High Court passed the order dated so-and-so striking down the Assam Fencer Education Institutions Provincialization of Services Act 2011. This was followed by repeal of the Assam Fencer Educational Institutions Provincialization of Services Act 2011 and enactment of the new Act Vice number so-and-so, date so-and-so, and recommend so-and-so. From the facts narrated above, it is observed that the incumbent has been deprived of the benefit of provincialization of her post due to delay in process and no fault of her. Therefore, her case deserves to be considered for provincialization. Now, my lord, due to bureaucratic delay, they have caused delay in not provincializing my post. Supreme Court has on various occasions said that due to delay on the part of bureaucratic or repetitive, etc., a person should be deprived his right. So, though the act has been repealed, but my case is much earlier than this. I have been appointed in 2004, my lord, and I was qualified. Repeatedly, they are saying that my post should have been provincialized earlier and I should not be deprived. Now they have filed an affidavit, my lord. My lord, there are Supreme Court judgment. By affidavit, a case cannot be improved. By affidavit, only the facts are brought to the notice of the Honorable Court. The law will decide what is the fact of the case or not. But affidavit, they want to say something by filing affidavit which their officers are not saying. Officers are not only officers, it is the government. This letter is issued by the Elementary Education Government of Assam to the director, my lord. So when the government itself is saying that I have been deprived for no fault of mine, now by filing this affidavit, whether they can deny this, then let them say this is not correct letter. If it is correct, benefit should be given to me. If it is not correct, then action should be taken against the person concerned why he recommended this, that vacant means everything abolished. Abolished, yes. But if this at present it is abolished. But my case is of 2004. So, my lord, if your lordship is on this point, by filing affidavit, a case cannot be improved at all. Affidavit. So, then I am ready to supply tomorrow itself also.
Lordship, a small rebuttal, my lord. Small rebuttal, my lord.
How can he rebut?
My lord,
His
just a small
government
rebuttal.
is saying, my lord.
My lord, a small rebuttal I would like to point out.
No,
Based on-
no, Mr. Fukan, let him complete.
Yes, my lord.
Yes.
His government is supporting my case. How that, my lord, there are so many judgments. My lord Justice Arijit Pashat has said in repeated judgments that the court shall follow the rule of law, not they shall hear the submissions which was uncalled for on the part of the other side, that means government or treasury bench. So those judgments we are having. So, my lord, my all limited prayer is this. Wrongly a person's name was, my lord, where is human? Yes, the scrutiny committee committed mistake, they have admitted. They have written to DO and DO has written to director has written to government, government says yes, wrong is there. So that's benefit should be given to me. Why they are behind me unnecessarily?
Okay. Yes, what is your answer?
Lordship, the lordship comes to page 43.
1 minute, my lord. 1 minute, my lord. I have to go to court number 1. For a moment, I am leaving. My junior would be here.
Okay, okay.
All right, ma'am.
My lordship, lordship comes to page 43 once more.
Mm.
43, the same letter which the learned counsel has shown, my lord. This letter, your lordship, comes directly to the bottom part, my lord.
Mm.
This letter says, this is a letter from the additional secretary to the director. Your lordship, kindly see, in view of the above and the bottom part, in view of the above and in keeping with the revised norms under the SM Education, Provincialization of Services, Teachers and Reorganization of Education Act 17, you are requested to place the matter before the state level committee for consideration, my lord. And you see the word consideration.
Mm.
So the additional secretary has just said that if there is merit, consider the case, can consider or reject. Consider towards provincialization of service of Anjura Khatun as assistant teacher under LP school under DO, that means under the new act. Accordingly, the SLSC has taken this letter into consideration,
Mm.
looked into the matter of the compliance, has looked into the matter of the petitioner, and therefore, my lord has come to the conclusion that this, and my lord, the other part also, this after that, this is necessitated as the Act of 2011 has been repealed. The Act which Learned Council has shown you has read just now is the 2011 Act, which has been repealed. Shut down.
Mm.
After that, my lord, 2017 Act has come. Now, after this letter has said, it is given by the additional secretary to the director, saying that kindly consider this case of the petitioner, whether she is eligible or not. If eligible, if not eligible. Accordingly, SLSC has taken note of the situation. SLSC has complied and gone into the case, and your lordship, SLSC has to follow rules, my lord, because this act is a statutory rule, act by Article 309 of the Constitution of India. As per this act, my lord, district scrutiny committee, as per definition 2H of the act itself, which is a statutory rule, my lord. It itself says that district scrutiny committee means district scrutiny committee, sorry, I mean not DICE code. DICE code means direct district information system for education code prepared by Sarvaskrishna San and as available in the records of National University of Education Planning and Administration. So in those records, her name has to be there. If it is there, then we will obviously may not be a beneficial legislation. We will have to accommodate her because as per rules we have to go. So accordingly, that was done. In the affidavit also we have filed, madam. That was checked. Her name was checked, and after threat-based scrutiny, it transpired in the affidavit itself. I have shown in the annexure also, annexure 2, that her name is there, my lord. We are not disagreeing that she is not there. She is there, but her name is there from 2016 onward. Now, my lord, automatically another rule applies here. When that happens, it's rule 4. We are bound by rule 4. Rule 4, if your lordship comes again to page 114, my lord. Rule 114. Page 114, rule 4.
Yes.
Rule 4 again, my lord, teachers and tutors to be government servants. Who are teachers and or tutors to be government servants. subject to fulfillment of all the provisions of this act, that is the 17 Act. The services of the teachers and or tutors of all venture educational institutions eligible under Section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Two, we are considering two. Teachers and tutors to be provincialized under 4(2). Teachers or tutors to be provincialized under this act. Who are they? 4(2)(3). Because she is claiming to have served from 2004, but her in the records she is showing from 2016. Automatically, Rule 4(3) comes in, my lord, saying that must have rendered at least 6 years continuous service. She has not rendered 6 years continuous service, my lord. She has been serving from 2016. That is prior to provincialization of the school, that is from 2013. If she has served from 2016, my lord, it is given clearly here that this is a statutory rule, my lord, must have rendered at least 6 years continuous service as on 1/1/17 from the date of joining in the concerned venture education institution, which must be on 31/12/2010 or prior to that date, my lord, 31/10, my lord, 2010. And she has come in 2016, my lord. How can she claim now, my lord, that she should get parity with the other two people, the judgment which they have showed? The order in the additional affidavit is of a person who is Solindra Sharma, who has been appointed by the Directorate of Secondary Education. How can she claim parity with that person who is from a different directorate? 17 Act does not apply there. A different set of rules apply in the secondary education matters, my lord. Lordship knows. In the higher education matters also, my lord, separate rule applies there. So as per the rule mandates, my lord, the rule mandates that 4(1) applies, and also the Dias Code 2H. So 2H and 4(3), 4 subclause 2, Roman 3 directly. This is a statutory article 300 directly my lord goes against their case. So therefore, my lord, looking into this, my lord, I therefore pray that their arguments have got no legs to stand, and therefore, my lord, will dismiss this case, my lord, because
Okay.
My lord, I want to reply. I want to reply against this submission, my lord. We are talking about 2011 Act, and my lord, he is relying on 2017 Act. My lord, why we are taking shelter of 2011 Act, my lord? My name was recommended, my lord, in the rectification letter in the year 2014. Lordship, kindly have a look, page 37. In the year 2014 itself, my lord, the district level scrutiny committee recommended my name, saying that the earlier recommendation was wrong. My lord, kindly see page 37. This I already have referred, my lord. 2014, my lord, my name was recommended freshly. That her name was, my lord, due to oversight.
No, that's already, Mr. Mahmood has already pointed out this.
Lordship. Now, my lord, now, my lord, why he is saying that the 2011 Act is only pertains to elementary education, not for the secondary education? My
No,
lord,
no, Mr. Mahmood has already argued on that point.
And my lord, in the
Don't repeat the same thing.
37 they have relied, 37 page 37.
Okay,
That has been
okay.
passed by the DEO.
Okay.
DEO, my lord, is not the appointing authority. There has no
Okay.
my lord, meaning.
Take down, heard Mr. Mahmood, learned counsel for the petitioner. Mr. Fukun, learned standing counsel for the respondent in elementary education department. Madam, you are here for respondent number 4. Mr. Bhattacharya, you are here? No.
No, I'm not.
Argument concluded, order reserved.
all right.
Number 23.
My lord, it is a transfer petition, my lord, filed by the petitioner wife, my lord, for transferring a divorce suit pending before.
No, the matter was referred to
Yes, my lord.
mediation.
Yes, my lord. We already settled, my lord.
Settle?
My lord.
Okay,
My lord, there is a terms and condition that has been report has with the record, my lord.
okay.
My lord, as per report, my lord,
Hmm.
terms and condition, my lord, the husband should pay rupees 6,25,000.
It appears that by order dated 11/2/2026, the matter was referred to the Gauhati High Court Mediation Center for mediation, and accordingly, the mediator has filed one report
Dated
on 9/3/2026.
There is some specific condition here in the report, my lord.
Then, in terms of the settlement made before the mediator, they have prepared to an agreement also, and the same is enclosed with this, enclosed with the report of the mediator. The learned counsel for both the parties submits that, since the matter has been settled in the mediation, this petition may be closed and the parties may be directed to appear before the Court of Learned Principal Judge, Family Court, Family Court number 2, Kamrup M,
Met-
Gauhati.
On, my lord, on
So-
22nd April, my lord, on 22nd April, my lord.
Which has been fixed on 22nd of April 2024 for receiving further direction in terms of the agreement,
Yes.
in terms of the agreement dated 9/3/2026. In terms of this transfer petition stands closed.
Interim order vacated, my lord.
Interim order passed earlier stands vacated.
I think. Obliged, madam, highly obliged.
Item 24.
Yeah, please, Lord. Worship, in this matter, we could not procure the alternate address. However, my lord, they are appearing before the learned trial court. So we are trying to get the correct address through the council in the trial court. My lord, 2 weeks time may be given so that we can contact the learned council before the trial court.
Okay, heard, Mr.
D. Mazumdar, Lordship.
D. Mazumdar, learned counsel for the petitioner. Mr. Mazumdar submits that though there was a direction to procure the correct address of the respondent and to take fresh step, the learned counsel for the petitioner submits that the respondent herein is appearing through his counsel before the learned trial court, and he may be
Title execution case, my lord. They are appearing in the title execution case.
in title execution case number
2 of 16.
2 of 16. 2 of 16. And you want to get the service effected upon the respondent through his counsel?
Through his counsel, my lord.
Okay, and he may be allowed to effect service upon the respondent through his counsel. Through his counsel. Where allowed? List the matter after 2 weeks.
Much obliged.
25.
Madam, this is service for notice. I think other side enter the appearances. Lord's may fix this matter for admission.
Admission hearing.
Lord's, otherwise division is not maintainable. They have filed a petition against the appellate judgment and decree.
Against?
Appellate judgment and decree. Judgment passed by the appellate court.
Lordship,
also. Third step.
it is a matter of hearing. Once there is a perversity, wherever, then revisional jurisdiction can be exercised. Supervisional power can be exercised. Lordship, it's a matter of debate. Let's fix the matter for admission here.
That's the fixed on the 22nd, Lordship.
Lordship, 26 we have little difficult. First week of May.
The suit was for?
Suit was for declaration, cancellation of solicits and for permanent injunction.
There is a error while the decree was prepared, my lord. That is not in consonance with the judgment, my lord.
They
And
have,
that was affected. Therefore, my lord, seeking that corrections only, my lord. The prayer which has been rejected, against which, my lord, we have 5 revision petition.
far as my learned friend has not been well advised.
Lordship, can I
After
see?
the judgment was passed, this appellant respondents has filed an application, review application, stating that since the trust has
the trust has not been reconstituted after the date of the president and secretary. So therefore suit is also abated. And that review application was allowed by the appellate court and consequently decree has been passed. So that part is missing in this record. Here is the review application, there is the order lordship that are not annexed to the petition. At the first instance, appellate court dismissed the appeal since it is abated. Because the plaintiff number 1 is the trust and the plaintiff number 2 and 3 are the secretary and president secretary. Both are dead.
So whether against a review order, this CRP is maintainable.
My lord, reason is that, my lord, so far that appellate order is concerned, definitely, my lord, that against which we have to go for second appeal, my lord. But there is a question, my lord, there is a inconsistency between the order that has been reflected in the decree and the appellate order. That corrections is required, my lord, because that must be consistent in between that, my lord, two parts, my lord. Therefore, my lord, revision petition only to see that whether that the mistakes appear on the face of record or not, my lord. That is our case, my lord. We are not going to make up the case, my lord, anyway.
No, even then, where no
My lord, we
revision is
satisfy,
provided.
my lord, if suppose there is a scope for suppose appellate, the appeal, my lord, instead of revision, my lord, then definitely will satisfy to this honorable court that under these circumstances, that 227 power can be exercised. Because all time, my lord, is not necessary that, my lord, because that there is a appellate order.
Learned counsel for the petitioner. And Mr.
Yes.
As Deca, learned counsel for the respondent, it is submitted at the bar that this matter service is completed and the parties entered appearance, and as such, the matter may be listed for admission hearing. Accordingly, it is provided that SSL list the matter for admission hearing after vacation.
My lord, first week of May, my lord.
First week of May.
May, my lord.
Okay. Suggested that on
8 May.
Okay.
Deeply, my lord.
Item 26.
Please, your lordship, my lord, in respect of the respondent number 5, 9 and 10, my lord, services awaited, my lord.
respondent number
5, 9 and 10, my lord.
5, 9 and 10.
My lord. Services awaited, my lord, and in respect of, my lord, 11 and 12, my lord, allow me to take fresh step, my lord.
Okay. Heard, Mr. Your name, please?
HP Gwala, my lord.
HP Gola, learned counsel for the petitioner. And you for?
Respondent number 2, 3 and 4.
Respondent number 2, 3 and 4. Mr. Bhattacharya? Oh, with her only. Okay. Okay. The learned counsel for the petitioner submits that as per office note dated 30/3/2026. Service report in respect of respondent number 5, 9 and 10 are awaited. And he also submits that in respect of respondent number 11 and 12, he may be allowed to take fresh step. They are allowed step be taken by speed post and also by usual process within a week from today upon respondent number 11 and 12. In respect of service report, however, in rest of the respondents, service be awaited. SSL is the matter after 4x.
My lord. Obligement.
Item 28.
May I please, your lordships? We filed an IA lordship for early hearing of this case, lordships.
When?
Month of May, lordships.
Month of May.
This is I for the appeal lordship. It's a appeal of 2023.
But they are because after execution, executing court delivered possession, they forcefully evict me. That's why I wanted to.
Both the side appeal has been indicated, and
But month of May, Lordship.
Person is suffering from ailment, but without any support of any document.
79 years, but why he objected? Because he forcefully evicted after delivery of possession by the executing court. This
Okay, okay.
specific case in the IA in the.
Heard Mr. Borbogaya, learned counsel for the petitioner. Mr. B. Halder, learned counsel for the opposite party. Mr. Borbogaya submits that this interlocutory application is preferred for early hearing of the RSN number 25/2023. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, it is provided that rest shall list the matter. List the RSN number 25/2023 on suggested that
21st May. Obliged.
in terms of this high instance clause.
Item 29.
Meet with your lordship. Your lordship was pleased to allow one writ petition, my lord. The relevant portion is at page 37, my lord. Okay. Along with one, my lord, interlocutory petition, both were heard together, heard the advocates of both the sides. Then your lordship was pleased to pass the relevant at page 35. Your lordship has got it. Yeah. Under the given facts and circumstances, I find sufficient merit in the petition, and accordingly the same stands allowed. By a mandamus of this court, the respondent number 2 is directed to process the application dated 31/3/22 and subsequent application dated 2/5/22 filed by the petitioner's college in accordance with the procedure prescribed under Regulation 5.2 of the University Grant Commission, Regulation 2009, and thereafter as per rules so and so and so and so. Along with this, my lord, your lordship was pleased to dispose the at page 12, my lord, IA, which was heard together. At page 13, my lord, relevant portion.
Mr. Borbogaya, whether service completed in this matter?
My lord,
Service completed.
copy.
In this matter, service completed.
Huh?
Completed, but ID card not returned.
No, no. It's a copy to this, itu 373820.
Dear my lord,
Bar Council of India is the main part.
main party, but I'm not the counsel for Bar Council. My name has been shown against the Bar Council of India, my lord.
Okay.
I'm not the counsel for Bar Council of India.
He has also been served.
They have Papa Pandu, but I am not the counsel, my lord.
Okay.
Okay, Nikita, I'm not the- Nasa Nikumas.
Only very small point, my lord. Your lordship has seen the order in the IA. IA says that in view of the order passed today on 3782/22, the IA stands disposed of. So now, my lord, armed with these petitions, they say that you first obtain the NOC from the state, then you will get the approval. So for that, my lord, your lordship can go to your lordship's judgment at page 33.
No. You are appearing for?
They have the copy upon me, my lord.
So you are not the counsel for the bar council.
But my lord, registered post has to be.
So you serve the notice upon proper person.
Yes.
Heard Mr. A.C. Buragoy, Learned General Counsel, assisted by Sir Parsing, Learned Counsel for the applicant. Ms. Gayon entered appearance for the respondent number 4, but she submits that she is not the counsel for the, not the engaged counsel for the respondent number 4. In view of above, it is provided that the applicant shall take fresh step for service of notice upon the respondent number 4. Respondent opposite party number 4. And in respect of rest of the respondent, whether
This
service.
is not required, madam. They have implemented your lordship's order. Only bar council has not.
But they have been arrayed as a party in this application.
In
You are
the,
supposed to serve notice upon them.
this is, your lordship will see the first title. Here only one respondent, my lord.
Where?
Page 4, my lord, in this petition. Page number 4, Hamak so and so, so and so, so and so. Applicant IA versus Bar Council of India.
Okay, not respondent number 4, opposite party number 1. And Ms. Gayan submits that she is not the engaged counsel for the respondent opposite party number 1. Accordingly, it is provided that the applicant shall take step for service of notice upon the opposite party, respondent opposite party number 1 by speed post and also by usual process within a week from today. Additionally, dusty service is also permitted. Office is here, Bar Council office.
My lord, we can serve one
By dusty
by
mode.
hand here.
Yeah. Additionally, dusty service is also permitted after effecting service by dusty mode. An affidavit shall be filed before this court. Place the matter. After vacation,
Let it be. Huh? Yes, madam.
after vacation. So do we fix a date?
Date, sir.
Okay.
Date.
Your lordship may fix according to your lordship convenience.
Your name is reflected in the cause title or the cause list.
Yes, my lord, that's one. Postal post. 99, correct.
Places shall delete the name of Ms. Gavin from the cause list. Okay.
No, oblige.
Submit.
May I please do, Lordship? Lordship, I have preferred a transfer petition of a title suit matrimonial case filed by my husband, Lordship, in Tinsukia. I'm seeking transfer from Tinsukia to Gauhati, Lordship.
Tinsukia to?
From Tinsukia to Gauhati, Lordship.
Yes, you are paying for respondent number?
My lord. My lord, we need some time to file objection, my lord.
Okay.
Today's Lordship case fixed for consideration of interim also because on the initial date Lordship interim was not provided and the case is fixed on 8/4 Lordship on next month Lordship. So I am paying Lordship an interim prayer and I want to stay praise for interim because on 8/4 it is fixed Lordship. Otherwise the matter will proceed ex parte Lordship.
Yes.
Hello, did I appear, my lord?
No, Lordship, I could not appear. That's why I have prepared this petition before your Lordship, seeking with some grounds, Lordship.
My Yeah, I'm also living in Arunachal Pradesh, my lord. That's why it is difficult for me to go to the Gauhati, my lord. I work in Arunachal Pradesh.
Lordship, the marriage was solemnized at Gauhati under special.
The learned counsel for the respondent submits that she may be granted some time to file objection in this petition. Pair allowed recessally is the matter for admission hearing on 7. In the meantime, the learned counsel for the respondent may file the objection.
Deeply obliged, sir.
31.
May I please, your lordship? Lordship, this is the review petition. My lord, what happened, my lord? Earlier occasion, we approached your lordship by filing a writ petition. And as per the lordship's order, my lord, we again filed, we have to file this review petition, my lord. That order is there, my lord. That order lordship will find at page 41. Why this review is filed, my lord? The lordship will find at page 42 the relevant portion, last paragraph, my lord. 42. It is noticed that if the pair of the petitioner for passing such direction is to be accepted, it would probably amount to reviewing the earlier order of this court through this writ petition. The same, in my considered view, would not be permissible. And accordingly, my lord, the liberty was granted to me to file the appropriate application, my lord. And review has I have prepared, my lord. Preferred. My lord, what happened, my lord? In this case, my lord, earlier occasion we approached your lordship on the basis of the statement, my lord. Lordship will find at page 29. Annexure 7. This is a TF appointment case, my lord. Annexure 9. There it is clearly stated that in the Department of Civil Engineering there is no post, my lord. And accordingly, what happened, my lord, at that time, my lord, lordship considered my writ petition number 2651. Observe that lordship order, lordship will file at page 30. And relevant portion at page 34, paragraph 6. I am reading, my lord. Mr. Borwa, learned counsel for the petitioners further submit that the respondent authorities have filed their affidavit in opposition and pursuant to the order dated so-and-so, Mr. Das, learned standing counsel for the respondent authorities has obtained instruction regarding the vacant post, and he submitted a copy showing vacancy status in Polytechnics of Assam as on Iman, which shows that no post under the Civil Engineering Department are laying vacant, and as such the pair of the petitioners in WPC number so-and-so could not be considered due to warrant of vacancy in the Civil Engineering Department, as both the petitioners in the said petitions belong to the Civil Engineering branch and industrial so-and-so branch, and as such their pair cannot be favorably considered. And accordingly, lordship at page 10, my lord, para 10, my lord, page 37, my writ petition has been dismissed. After that order, my lord, the petitioner has submitted an application. Lordship will find at page 38. Under the provisions of Right to Information Act, there he has raised, seeking some information. Lordship find that serial number 1 at page 38. Serial number 1. How many sanctioned lecture posts laying vacant in the Polytechnics of Assam in the Civil Engineering Department? This notice, this application was filed on 18/12/2025. That is after passing of this lordship's order. And in response to that RTA application, my lord, the respondent authorities provided, lordship will find at page 40, the response, provided the response to the petitioner. Provided the response of the petitioner that point number 1, one post is
This
laying vacant.
information was furnished when?
Lordship?
After passing of the order.
Lordship's order. That is in the 2651 writ petition. They are, my lord, at that time, my lord, they have
On the
submitted
date of passing the order, this fact was not available before this court.
Because there at that time, my lord, they have misled the court, my lord, by submitting the status of the vacancy status where civil engineering lecturer post was laying vacant, but they have said there is no post. That's why lordship has passed
On
this
the
order.
basis of this subsequent facts obtained by you by filing RTA application,
Yes.
Can this court again review the order earlier passed by this court earlier?
Yes. At that time, my lord, it was not in the knowledge of the petitioner, my lord.
Maybe
And
it
my
may
lord,
give rise to subsequent cause of action.
yes, my lord, that's why, my lord, earlier occasion I have filed a
No. What is the ground for filing the review petition?
review petition on the basis of this order, lordship.
Hmm?
This order, that is page 41.
No, on the date of passing the order under review, this information was not placed before this court.
Not review on the writ petition,
Yes.
on that writ petition, and that information was not furnished to us. Later on, my lord, on the benefit of doubt, my lord, we have filed an application before the court, before the respondent authorities.
No, I don't think this review petition is maintainable.
My lord, writ has already been,
Maybe.
writ court, my lord, already in the writ petition. After that, my lord, is the first cause of action. I have filed a writ petition, my lord. That is on page 41, my lord. Can you see, lordship?
Page
41. 980. Raise this thing, my lord. I'm reading the entire paragraph, one page order. Mr. D. Borwa, learned counsel for the petitioner who submitted the petitioner along with another person has approached this court earlier by filing writ petition number 2651, where lordship has passed the order, claiming for a direction to the respondent authorities to consider them for appointment as lecturer under the provisions of regulation TF of the APSC Limitation and Function Act so and so. The said writ petition was taken up along with writ petition number 2665/2025 and disposed of by common order dated so and so. This court, after noticing that the vacancy status in Polytechnics of Assam to be filled up through the direct recruitment as on so and so, did not include the post of lecturer technical in Civil Engineering Department, Annex 7, declined to pass any favorable order in favor of the petitioner. The incident petitioner not being satisfied applied for the certain information regarding the vacancy status in Polytechnics in Assam in Civil Engineering Department through RTI, and response to that the response he received was that there is one post. The learned counsel therefore submits that since there is no one post available, the similar direction may be passed for the considering the case of the petitioner for appointment to the posted question under the regulation TF was directed by the order dated so and so. And then the court say it is noticed that if the pair of the petitioner for passing such direction is to be accepted, it would probably amount to reviewing the earlier order. And accordingly, my lord, by next paragraph says the counsel submit that he may be allowed to withdraw the writ petition with liberty to file a appropriate application. In view of the above, the writ petition stands disposed of as withdrawn with the liberty to file the appropriate application as permissible in law. This is a fresh cause of action, but lordship says like that, my lord. That's why, my lord, I am filing the review application.
No, perhaps you failed to satisfy that court.
That's 6 and 7, 6 and 10 paragraph, my lord. Earlier occasion, there is in the writ petition number 2651, my lord, there are two petitions.
So this order was passed on
11/9/2025.
And what is the period of review?
Lordship,
What is the limitation for review? Filing review petition?
1 month, my lord.
1 month.
That question was I raised before the court, my lord, I played before the court, and therefore, my lord, court has given me the liberty, giving me the liberty to file the application. That's why, my lord, my problem is that, my lord, as per the lordship is very much correct that this is the new cause of action, my lord, after getting the response under the Right to Information Act. And Right to Information Act, and I have filed a writ petition, my lord. And court says, lordship says that it is the amounts to be reviewed.
No,
As per
I'm
that
not
order
saying
from
it.
if lordship found that the earlier vacancy question which has been placed before this honorable court was our appendix page number 29. It was around 1/9/2025, that is prior to passing of this that order, madam. Now the RTI reply where it is showing that what vacancies they are kept as on 21/1/2016. That was the vacancy I think subsequently, madam, after passing of that order. although my friend is saying that at that point of time, department has misled this code, my lord, but that is not true, my lord. That was the vacancy at that point of time, relevant point of time, there was no relevant. Subsequently, my lord, due to promotion and all, one vacancy arises, that is subsequently. My lord, the review, why review is not applicable here, my lord. The review says that error occurred on the face of the record, or my lord, something which the petitioner could not bring to the notice of the court, although that fact was already there at the time of passing of the order. But here, this fact is subsequent event, or subsequent fact. That vacancy was not there at the time of filing, at the time of passing of that order, madam, by your lordship. So this review application is not applicable here, madam. Now, madam, regarding limitation period, limitation is, madam,
1 month.
this court has also already passed an order that
11/9/25.
30 days period, madam. Can you see, madam? The order was passed on 11/9/2025. Then when he applied for the RTI petition, RTI applied for page 38, 18/12/2025. And that the review, the limitation for review has also done. Now, court says that, madam, there is judgment of Supreme Court which says that, madam, the liberty granted by a court cannot outstay the limitation period where, madam, the cause of action has already gone, or cannot revert the cause of action which is already gone, madam. There is judgment also. Now, madam, at that application will file, or at that earlier petition will file within the period of review 30 days, then his limitation would have come, madam, after granting liberty to approach the appropriate court.
Okay, I don't think you will get any relief in this matter. Even then, you first file your application for condonation of delay. Only thereafter we will see it.
No, actually, what happened, my lord, I am coming to the review, coming with the review application after lordship's order. That order, earlier I have filed a writ petition by raising that new cause of action, my lord. In that new cause of action, while this case.
No. First, you have to file a application for condonation of delay.
No, writ petition, my lord. I am coming to the page 30. Not page 30, lordship. Page 41. That order passed on 23/2/2026. At that time, my lord, I approached the court with the new cause of action under the provisions of 226. And at that time, lordship say, this is not the proper, this, if any direction or any observation is to be passed, that is amounts to be a review to the earlier order, that is lordship's order, to September order. And accordingly, from that day, my lord, if it is counted from that day, my lord, it is under the period of the limitation, my lord.
No, limitation will be counted from who is that? From the date of passing the order under review or judgment under review. This judgment was passed on by this court on which date? 11/9/2025.
I raised this question, my lord. At that time, I pay for that observation also for the court, my lord. But court said, my lord, that this limitation period will be counted from that day, because earlier, my lord, while I have received the response from the respondent authority in respect of the RT application, then this is a totally a separate cause of action, my lord, from that earlier order. That's why, my lord, I approach your lordship by filing the writ petition 980 WPC. And in that writ petition, my lord, this observation has been filed. After this observation has been made by your lordship. After that observation, my lord, all those has closed, my lord.
Before admitting this review petition, we have to condone the delay.
My lord. Then, my lord, I may be given the liberty to file a delay condonation application first.
Okay.
Yeah, actually, what happened? That writ petition where it was granted to my petition, there actually the petitioner has drafted this petition in such a way that he was seeking to review this order, the order passed by the Honorable Court.
Okay.
He wanted to correct something in that order. That's why this
Order was passed.
Otherwise it is separate cause of action, because at that point of time, what was there, now this is subsequently arising vacancy. So at that point, now whether his case can be considered pursuant to this scheme of PF, this is separate cause of action. But he has without having any effect to the other earlier order passed by this honorable court.
No, actually what happened, my lord, entire his submission is arose after the passing this lordship's order dated 23/2/2026, my lord. That time, my lord, I may be allowed to given the liberty to file a delay contention application, my lord. After that, my lord, that may be considered.
Okay. Heard, Mr. Borua, learned counsel for the petitioner. Mr. S. Das, learned standing counsel for the higher education department. Mr. Borua submits that he may be granted liberty to file an application for continuation of delay in preferring this review petition. Pair allowed or SSLize the matter after vacation.
Yes. My lord, one pay, my lord, the earlier case, my lord, I is supposed to submit a documents, my lord. That documents, my lord. I will submit
Which
it.
matter?
37, my lord. Earlier matter I had appeared in the morning.
Okay, okay,
That has already been reserved, my lord.
okay. Okay.
In terms of the direction passed by the honorable court, we have submitted the amended course title, but perhaps that has not been the part of record. Lordship may kindly call that, my lord, amended course title from the registry, my lord.
When the order was passed?
My lord, this directions passed by the honorable court last was like on Monday we have submitted. Monday we have submitted, prior we have submitted.
IA number?
Yes, madam. I.
Not in I, in the
Main CRP, the direction was given.
Okay.
I was disposed of directing us to submit the amended course title, madam. That we have followed, madam.
This IA has been disposed of?
Yes, my lord.
No, IA number 9.
Another IA filed by them.
We have filed I for under section 151 of CPC for restraining respondent number 1, sub town committee.
My lord, the position is that, my lord, a injunction petition they have moved before the executing court. That was dismissed, against which they have filed this IA incorporating section 151, my lord. But it is a matter of maintainability of this petition, my lord.
Matter to come for admission.
Which matter?
This CRP. Today's for admission.
No, today is for orders, my lord.
Okay.
First, my lord, that amended course title is required, my lord.
Okay. Heard, Mr. Samaria, learned counsel for the petition. Mr. Your name, please?
P. Sharma.
P. Sharma, learned counsel for the respondent number?
5.1,
5.1,
5.2, 5.3, and 5.4.
5.4. And you?
Respondent 1.
Respondent number 1. Mr. Samaria, learned counsel for the petitioner submits that pursuant to the order passed in the IA, the petitioner has filed amended cost title on Monday.
Monday, madam.
But the same is not placed on record. Accordingly, it is provided that SSLize the matter after vacation.
Madam.
Lordship, can it be on 8th of this month?
No, my lord, not possible, my lord. It's a short notice, a required, my lord, admission hearing, detailed time.
Lordship. Against a correspondent, they have filed this against a correspondent. Injunction petition practically, Lordship. In a CRP filed by someone else.
It's a matter of, my lord, everything.
For injunction, a totally new cause of action against, if at all their petition is taken at part, then also they have to go for a suit. New cause of action against Chabot Town Committee only. How they can come
My lord,
back?
after, my lord,
Let it be on 20th of April. 20.
my first way, my lord, first week of May, my lord, I will be out up to 20, my lord.
29th approximately possible.
Or 29 or first week, my lord, no problem.
29. Okay, 29.
My lord,
Lordship on 21.
20 will be not.
29.
Interim order is there, my lord.
29.
Interim order pass earlier self-fulfilling.
Much more.
It will IA task it will list this IA along with CRP number 220 of 2025.
May I please your lordships? Lordship, I am the applicant, plaintiff, respondent, the instant second appeal. My suit was defeated. Suit for right to enter the recovery of possession, lordships. I filed this application for early hearing, lordships, and this honour court already granted liberty to both the parties.
Mr. Corvoya, learned counsel for the applicant. And you for?
For all the respondents. in this IA.
Respondents appellants. They are in the second.
Your name, please.
R. Shah.
Or Saha, learned counsel for all the respondents, for all the opposite parties, struck. Appellant. Appellant. Mr. Barboya submits that this application is filed for early hearing of the RSA number 219 of 2023. Accordingly, taking note of the submission of a learned counsel for both the parties, it is provided that SSL lists the RSA number 219 of 2023 for hearing on
The month of May, lordships.
26 May.
26 May.
26 May. In terms of this, IA stands closed.
Item 38.
Obliged.
May it please your lordship. Your lordship, in this matter, as per the office note dated 30/3/2026, service report is awaited, my lord, and TCR has not yet been received. So kindly,
Service completed.
yes, your lordship. Kindly reminder may be
Miss,
issued.
your
for
name,
TCR.
please.
S.A. Murtaja on
S.A.
behalf of Ms.
S.A.
R. Chaudhary.
Murtaza, learned counsel for the
I'm appealing for
appellant.
point number 1. Yes, your lordship.
And Miss
F. Hintas.
F. Hintas, learned counsel for the respondent number
1.
1. 1 or 1 to 8?
1, lordship.
1. The learned counsel for the appellant submits that service in respect of respondent number 2 to 8 have already been completed. However, the record, which record? Appellate court record or trial court record?
Trial court record, my lord, has not yet been received.
Appellate court record has been received.
Yes, your lordship.
No record. Submits that the trial court as well as the first appellate court records have not yet been received. Accordingly, it is provided that SSL issue urgent reminder to the learned courts below for transmitting the record without further delay. List after vacation.
Yes, lordship. Any date, your lordship?
COVID.
On 13th May.
Obliged.
Item for admission. Item number 3, Contempt method.
Last question, PP Dotto appear, my lord, and he's supposed to apprise your lordship that matter is already examined by the authorities, my lord.
He is available, Mr. Dotto.
My lord,
He is available in the court.
in the morning, my lord, I talked with him.
Timing. Next slide.
Item 4.
That is lordship. This is a revision petition, lordship. We are agreed with the rejection of our prayer for extension of time for depositing amount, consideration price, lordship. In a specific purpose suit, a decree was passed in favor of me, directing lordship may come to page 15 to pay the balance amount within 75 days. Page 15 is the order part of the decree. Resultantly, the plaintiff suit and it is hereby decreed expertise with cost with the following reliefs. The plaintiff is entitled to specific performance of the contract dated 6/10/2016 for sale of the suit land, subject to the payment of remaining consideration money of rupees 10,000 to the defendant within the next 75 days from today, and the defendant shall execute and register sale deed in respect of suit land in favor of the plaintiff on receipt of the above mentioned balance amount. And B says if defendant fails, deed may be executed through the court. So we could not deposit within 75 days, lordship. Thereafter, we filed petition at page 20 along with the challan. It was a long delay, lordship. In the year 2020, the petitioner gave birth to a child, and thereafter COVID period is also there. Then we filed this application.
That was rejected. We
Page
filed it
number?
in 22.
Page number
Page 20 is the petition, typed copy petition. Lordship.
and the impugned order?
Impugned order is starts from page 26. Relevant part, Lordship, page 28, last paragraph starts. From the foregoing discussion, it manifests that it is pertinent for this court to look into the circumstances for such delay as well as the conduct of the plaintiff. It is seen that the time granted to the plaintiff for payment of the balance consideration amount was 75 days from the date of passing of the decree. The petition filed by the plaintiff for extension of the time apparently discloses that she became pregnant and went through several complications because of which she could not contact her engaged counsel. The petitioner further stated that she gave birth to a baby girl on 29/5/2020. The petitioner also showed the ground of COVID-19 for the delay on her part. Even if both the grounds put forward by the plaintiff are considered, there is still an unexplained delay of period of 1 year approximate. The plaintiff has not been able to show any justification for her total inaction for the aforesaid period. The period of total inaction on the part of the plaintiff is paying the balance consideration amount after the expiry of 75 days leads this court to believe that the conduct of the plaintiff does not show that the plaintiff was ready and willing to deposit the balance consideration amount. Although this court is vested with the jurisdiction to extend the period of depositing the balance consideration amount, the petitioner did not file any petition for extension of the stipulated period before expiry of the same. Neither there is any material to show that the plaintiff was willing and ready to perform his part, nor had he tendered or deposited the balance consideration amount as per the terms of the decree. So it has been observed. Now, is power under section 28(1) or section 28 of the Specific Relief Act is not similar under section 5 of the Limitation Act. Such petition, there is decision, Lordship, that court has the power. Court is not functions officio after passing of the decree. Court can extend the time. And such petition for extension should not be treated like a section 5 of the Limitation Act, where every delay has to be extended.
Section
28, Lordship, 28 of the Specific Relief Act. Even learned trial court also referred 28(1) in previous paragraph. He has referred 28(1). 28. Rescission in certain circumstances of contracts for sale or lease of immovable property, the specific purpose of which has been decreed. 1. Where in any suit, a decree for specific purpose of contract for the sale or lease of immovable property has been made, and the purchaser or the lessee does not within the period allowed by the decree or such further period as the court may allow, pay the purchase money or other sum which the court has ordered him to pay, the vendor or the lessor may apply in the same suit in which the decree is made to have the contract rescinded, and on such application, the court may, by order, rescind the contract either so far as regards the party in default or altogether as the justice of the case may require. Now, in our case, Lordship, judgment debtor vendor did not come forward for rescission of the contract. They did not come here also. This is one aspect. And where the contract is rescinded, contracts can be rescinded on the part of the judgment debtor, defendant judgment debtor. But power of extension is there under 28(1). Even 3, Lordship, subsection 3. Section 3, subsection 3. If the purchase or lessee pays the purchase money or other sum which is ordered to pay under the decree within the period referred to in subsection 1, the court may, on application made in same the suit, award the purchaser or lessee such further relief as he may entitle to include appropriate cases all any of the following reliefs, and no separate suit, Lordship. Execution of property on the cost. Now, the decisions, Lordship, although it should be at the sweet will of the plaintiff, decisions after many years also, Honorable Supreme Court allowed.
Where?
In relying on those decisions. One is 1997 decision, Lordship.
The second was 2025. First lordship 97 decision, maybe one page or one sheet lordship. Sardar Mahar Singh. Paragraph number 3 lordship. From the language of subsection 1 of section 28, it could be seen that the court does not lose its jurisdiction after the grant of the decree for specific purpose, nor it becomes functus officio. The very fact of that section 28 itself gives power to grant order of rescission of the decree would indicate that till the sale deed is executed in execution of the decree, the trial court retains its power and jurisdiction to deal with the decree of specific purpose. It would also be clear that the court has power to enlarge the time in favor of the judgment debtor to pay the amount to or to perform the conditions mentioned in the decree for specific purpose, in spite of an application for rescission of the decree having been filed by the judgment debtor and rejected. In other words, the court has the discretion to extend the time for compliance of the conditional decree, as mentioned in the decree for specific purpose. It is true that the respondent has not given satisfactory explanation of every day's delay. It is not, unlike Section 5 of the Limitation Act, an application for condonation of delay. It is one for extension of time. Under these circumstances, the executing court as well as the High Court had exercised discretion and extended time to comply with the conditional decree. Accordingly, you do not find any valid or justifiable reason to interfere with the order passed by the High Court, confirming the order of executing court, when in the particular, the High Court has further announced sum of rupees 60,000. 60,000 to compensate the petitioner for loss or enjoyment of the money. The said amount is given to the respondent in sum of rupees 16,000, rightly for the reason that parties contracted non-performance of the contract. So compensation has been, additional compensation has been given over and above here. And 25 decision lordship, it is clearly mentioned the same thing that court has the power. And in the last part lordship, paragraph 55. Hereafter, the balance sale consideration deposited by the appellant plaintiff way back in 25/29, that is to be 4,87,000 shall now be disbursed in favor of the defendants with interest accumulated thereon with a period of 4 weeks from today. Since there was a delay of 2 years in filing the execution petition and the delay of 4 years in depositing the balance sale consideration of rupees 4,87,000, we are of the view that the respondent herein, judgment debtors are entitled to simple interest at the rate of 9% per annum from the date of judgment and order passed by the appellate court till the date of the balance consideration is deposited. So interest, additional interest that is imposed, but it was allowed.
And how much interest you are ready to pay?
Lordship, as per Supreme Court, 9% has been imposed. In this case, 9% imposed. It may be either in interest form or like the previous judgment compensation. The balance consideration plus is 10,000. Whatever compensation lordship please do is. Both the sides are poor.
Which one will be justifiable?
10,000, over 10,000 lordship. It may not be double.
Interest or lump sum compensation?
Total 10,000 plus compensation, whatever comes. If it is 5,000, it will come 15,000.
Pass the order.
Obliged.
May I please note in item number 5, the consent of the
Obtain consent from the other side.
we have for the other side.
Item number 5.
My lords.
Yes.
My lords, learned ASG is on his way, my lords. In the meanwhile, I'll just start, my lords.
Okay.
My lords, may kindly have my note which we have submitted on the last date. I'll just recap, my lords.
Yes.
On 2 issues, my lords. One is how the IA, which is IA number 320 of 2025, is not maintainable.
IA number?
How it is 320.
Okay.
My lords, the IA 320 has been filed in contempt petition seeking for deposit and withdrawal of the amount determined in the by way of the award, my lords. My lords, may kindly note one crucial factor, my lords. My lords, the amount of 48 crores approximate has been deposited by us without prejudice to a right and contention in the writ petition, my lords, which has been recently filed, my lords. That, my lords, will find at page, my lords, page 17, my lords would see. Page 13, my lords, of the note. I have annexed the relevant order.
Yes.
I have my note, learned ASG's note dated 25/3/2026.
Yes.
Yes, my lords. In that note, page 13, annexure A1.
Yes.
The first order dated 18/2/2026 passed in the writ petition, my lords. Now, my lords, amount of 48 crores, my lords would see.
Yes.
At page 16.
Yes.
Is in the writ petition. I will read the relevant portion. The last paragraph. Considering that the award has been passed pursuant to the judgment and order of this honorable court, this court as agreeable by the learned counsel for parties in the earlier writ petition, which prima facie appears to be a consent order, and in view of submission made by learned additional Solicitor General Mr. Raju, agreeing to deposit the compensation amount, it is hereby provided that the petitioner shall deposit the said awarded amount of 48 so and so before this court within a period of so and so. So this without prejudice to the claim of the petitioner in the writ petition, my lords. The contempt, it is not deposited in the contempt petition, it is deposited in the writ petition. Contempt petition was thereafter tagged, my lords. My lords, the learned ASG is there, my lords. May I request my lords to?
Okay.
I am obliged, my lords.
I'm sorry, my lords. I'm sorry I kept.
Okay,
I
no
was-
problem. Okay.
As my colleague, Mr. Rajat Nair, was arguing, the amount is not deposited in the contempt petition, therefore the IA for withdrawal in the contempt is not maintainable. The deposit is in the writ petition, which is a separate proceeding. Therefore, this, in a contempt petition, this can't be. Now, I was arguing the contempt petition, if my lord recollects earlier.
Yes. Yes.
I had given the dates, my lords, and
Yes.
the date of the award, my lords. My lords recollect.
Yes. Yes.
Orders of 10th of February 25. And contempt is filed on 14/5/25 regarding the order of 10th of February 25. Now kindly have a look at the order, my lords.
Yes.
Which is at page 17. What are the directions, my lords? May kindly have a look.
Yes.
Page 51. Para 23.
Yes.
Since Mr. Tiwari learned senior counsel of the petitioner so and so, and respondent number 1, 4, and 5 is agreeable to pay compensation to the respondent number 3, so and so, and the petitioner so and so, who says they are entitled to under so and so, and since Mr. Das, learned counsel for the petitioners, is agreeable to accept the compensation whatever they are entitled to under the Act, the court is inclined to dispose of the writ petition in the following directions. We said we are agreeable to pay the amount provided it is a correct and legal order.
Yes.
This will not, but that agreement is not part of the directions or order of the High Court. It is only an observation of the High Court which observes that we are agreeable. The High Court doesn't say that. Now kindly have a look at A. What does the High Court say? Respondent number 2 and respondent number 3 shall constitute a board to reassess the compensation which the petitioners are entitled to for acquiring the land at Bhimsak Nagar as per so and so. So they have to constitute a board, no direction to make payment. That direction is for R2 and R3. No direction to the present so-called contemners of NHPC. Second, the board shall be constituted with adequate representation of NHPC. No, that is not violated. There's no such. The board shall assess the compensation in each of the components specified series taken into account provisions of so and so act, which provides for determination value of the things attached on land or building. The order doesn't say that after it is assessed and after the award is made, the NHPC shall make the payment. That the order doesn't say. Leaving it to the parties to go for execution of the award. Otherwise, the order would have said after the assessment is made, after the award is passed, the order would have said NHPC to make payment in terms of the award. That is not stated anywhere in the order. Then, my lords, will kindly have a look. The board shall assess the compensation that I've read. The respond number 2 and respond number 3 on the satisfaction about compliance of all the provisions of in assessing the compensation by the board, so constituted shall pass the award incorporating therein 12% interest annum market value so and so. Therefore, so the order is for constitution of the board and passing of the award. Beyond that, the order doesn't travel. Beyond that, the order only says pass and constitute a board, make the assessment, pass the award. It stops at that. The order doesn't say after the award is passed, it has to be paid. There is no such direction. My learned friend could have filed a review saying that yes, it's passed that direction. Now look at the order which I read last time, my lords, where my learned friend, now contempt was filed on 14/5. My lords, have got it?
Yes.
Look at the prayer at page 15 in the contempt. Initiate contempt of court proceedings under section 10 of the Contempt of Courts Act, that is civil contempt, my lord. Again, the respondent contemners for willfully and deliberate violation of judgment and order dated 10/2/25 passed by this honorable court in writ petition so and so Tunku full. So for violation of willful violation of the order dated 10th of February 25, which I have read. Then, my lords, may kindly have a look. Ultimately, the award is passed on 1st of August 25. So 1st of August, there was no award. So obviously, it could not have prayed in May that asked to punish them for contempt for an award which is to be passed in August. That could never have been the scope of the petition. And that was not the scope of the petition. Now kindly have a look at the 611 order, my lords, which I read last time. Page 37, my lords.
Yes. (6/11/25). My lords, may kindly note, award has been passed in August and this order is November, 3 months afterwards. Yes, yes. On the other day, you have pointed it out.
Yes. So he says that the order has been complied with.
Yes.
Therefore, contempt was closed. Therefore, once the order is there, the contempt is. But at the insistence of the other side, your lordships have issued. Has already complied. Second, submitted by Mr. Das, letter counsel that Deputy Commissioner has already complied with the court's order. Contempt of so and so have not appeared before this court. So only because we have not appeared that the notice was issued. Yes. Now I given written submissions, but my additional submissions further note. My colleague will hand over the note, my lord, to my lords.
Yes, yes, yes. Got it.
And compilation of orders is also being handed over.
Yes.
Now, before I go to that, kindly have a look at 2 judgments, my lords. Ambiguous or is it? Where is it? No. first judgment on which I'm relying is 2008-14 SCC 392. Have you got it? Have you given it? I'm sorry, Mura, it is not 392.
What did you not earlier note the other judgment this way to find?
This is also good. No, this is a new judgment. I'm sorry, it is not there, but may, if my lord permits, may I only read the relevant para, my lord.
Okay.
Slowly I'll read, my lord, but I'll give the citation. 2008, see, 392. Kindly have a look at para 28 of this judgment.
Okay, please repeat again.
2008, 14 SCC 392, para 28.
Yes.
The order of this court properly construed therefore would mean that the admitted lease would cover 16,000 square feet of land. Different treasuries like entire and admitted have been used by this court. Construction of the said order therefore must be resorted to upon reading the same in its entirety. It is a well-settled principle of law that if two interpretations are possible of the order, which is ambiguous, a contempt proceeding would not be maintainable. In state of Bihar versus Sonavati Kumari, it is, but here there is not even two interpretations, only one interpretation. And the interpretation that award is to be complied with is not there. Even if we accept my learned friend's submission that two interpretations are possible, the order also directs you to pay the award. Therefore, the second interpretation, which my learned friend, then also contempt proceedings do not lie, my lords. Then the second contention urged was that even if on proper construction order read in the light of relevant pleadings, the state government was directed to abstain from publishing a notification under section 3(1) of the Act. Still, if the order was ambiguous and equivocal and reasonably capable of two interpretations, the party who acted on the basis of one of such interpretation could not be held to have willfully disobeyed the order. Stated in this term, the contention appears to be unexceptionable for it being accepted in a particular case. However, two conditions have to be satisfied. The order was ambiguous and reasonably capable of more than one interpretation. The party being proceeded against, in fact, did not intend to disobey the order, but conducted himself in accordance with the interpretation of this order. Now, my lords, here, when he filed the contempt, there was no award. So where's the question of disobeying the award? Even according to his interpretation, even if it is accepted that the award indirectly or impliedly said that you pay the award, but on the date of the contempt application, nothing of that sort was done. Where's the willful? So to initiate a contempt application, there has to be willful disobedience. That willful disobedience is not making payment as per the award as stated by him. That was not in existence. How can there be a contempt of something which was not in existence? Then the second judgment, my lords, is 2002 4 SCC page 21. 2002 4 SCC page 21.
Okay.
Now kindly have a look at para 20.
Okay.
Last passentum D, my lord. The order of this court cannot possibly be interpreted as per the understanding of the respondents, but as appears from the plain language used therein. Neither is the order capable of two interpretations, several interpretations, nor is there any ambiguity in the same, does not require further clarity. The order is categorical, clear in its context and meaning. The court's orders are to be observed in its observance rather than in its breach. So, order has to be read. If the order is read, clearly there is no direction that the award has to be complied with. If that is so, there can't be any contempt. Now, kindly have a look at my note which I'm handing over just now, my lords.
Okay.
First point is no directions passed by this honorable court. There might be some little repetition of what I said, but I'm putting it. Judgment dated 10/2/25 did not pass any directions which can be or were to be complied by NHPC. The task of drawing the LA award is statutorily conferred upon the state authorities under the 2013 Act. The said statutory obligation cannot be relegated or delegated to third party, not even by an order of the court. But any intervention by third party in drawing of award itself make the award void and legally unsustainable. Since no directions were passed by NHPC, the question of non-compliance of this honorable court's directions do not arise. Second, there cannot be any implied contempt of the court orders. It is submitted there is no proposition as law as an implied contempt. The contempt of the court's order has to be direct, willful, and should be committed by person against whom directions are issued by the honorable court. As evident from the judgment dated 10/2/25, there are no directions issued for compliance by NHPC. As such, the question of contempt cannot arise. In law, only DC, Lower Dabang Valley was the competent authority to comply with the directions of this honorable. As such, any contempt can be maintained only for R2 and R3, not against NHPC officers. Then the third is present contempt proceedings was as such in pith and substance filed against respondents, alleged contemners 2 and 3 state authorities. The alleged contemners before this honorable court on 14/5/25, where the respondent alleged contemners number 2 and 3 state authorities. Allegation in the contempt petition was that despite 3 months granted by this honorable court, the award was not passed by them. The officers of NHPC were named only because they were implicated in the main writ petition. However, their legal status was not more than that of performer of respondents in the contempt proceeding. This is evident from the fact that in 14/5/25 and till 6/11/25, they were neither served in the contempt petition nor were they heard. So conduct speaks for itself, conduct of the petitioner. Since the contempt was alleged against respondent numbers 2 and 3 state authority, therefore application 130 was referred by the respondent alleged contemptor 2 and 3 seeking extension of time for passing the award. Award came to pass on 1/8/25. That contempt petition thus concluded. The fact was also recorded in order dated 6/11/25 passed by this honorable court in the instant matter. The present contempt proceedings stood closed while order dated 6/11/25. This fact has been admitted by the contempt petitioner. That order dated 10/2/25 stood complied with. This I have already argued, so I may skip para 7, my lord. Once para 8, once the award was passed and order that stood complied with, statement is behalf was recorded. Then the next, my lord, at page 3, ex facie malice, attempt to convert contempt proceedings into coercive, intimidating execution of proceedings when the order stood already complied with. It is submitted that the orders and the interim applications filed subsequently to passing the order dated 6/11/25 makes it ex facie clear that notwithstanding the recording of the statement on 6/11/25, an attempt was made by the contempt petitioners to intimidate the officers of the NHPC and arm twist them under the threat of present contempt petition to pay the monies determined in the award without permitting them to take such recourse against the fresh award as prescribed in law. To achieve the said end, the contempt petitioner first moved an application IA to implicate respondent number 6 and 7, the senior functionaries of NHPC. Furthermore, to convert the present contempt proceedings into a coercive execution proceeding, contempt petition filed another IA interlocutory application came to be filed seeking the following prayers. In the premise aforesaid, it is therefore most especially prayed that your lordship would be gracious to please to admit the application and direct contempt number 1, 6, and 7. The officials of NHPC authorities deposit the awarded compensation within a period of 2 weeks for appropriate disbursement to the applicant. After passing the order dated 6/11/25, this IA was neither maintainable, nor tenable, nor sustainable in the eye of law. The prayers made in the IA have changed the nature and scope of the contempt proceedings to execution proceeding, which is not legally tenable. Then, my lord, maintainability IA 320/25. It is submitted very filing of said IA suffers on patent and manifest jurisdiction error, inasmuch as prayers sought therein are wholly alien to the scope and ambit of contempt jurisdiction, can neither be entertained nor granted in the proceedings of the present nature. It is stated none of the provisions of contempt of courts can be made applicable to adjudicate and grant such prayer. It is stated that order dated so and so itself records as under. By filing this applicant petitioner are seeking direction to respond number 1, 6, and 7 to deposit and release the awarded amount.
All of this is happening 8 months after filing of contempt petition.
This is after 8 months of filing of the contempt application. So this is One can understand, you can pray for purging of the contempt, but when you are not, the prayer is not for purging of the contempt. When the order is complied with, this is in the nature of execution proceedings. It can't be done. One more point, my lords. Kindly look at the Contempt of Courts Act. Section 10 on which it is based, civil contempt, my lords. That is of the. It is of a subordinate court. I do not know. Section 10 itself is not meant to, it is for punishment to commit contempt of subordinate court. Every court shall have the exercise of the same jurisdiction powers and authority in accordance with the same procedure and practice in respect of contempt of the court subordinate to it as an exercise in respect of contempt of itself. So section 10 is not applicable because it is contempt of the orders of the subordinate court. This is not contempt of the subordinate court. Now look at what is civil contempt. Section 2B. Civil contempt means, my lords have got section 2B of the Contempt of Court Act.
Yes, okay.
Civil contempt means willful disobedience by any judgment, decree, direction or order, writ or other process of a court or willful breach of an undertaking given to a court. So willful disobedience to any judgment, decree, direction, order, writ or other process of the court. So there is no judgment, decree, direction, order, writ or other process of court which has been willfully disobeyed. The order of 10th of February doesn't contemplate anything which has been breached by NHPC or willful breach of an undertaking given to a court. No undertaking has been given. Undertaking, what is undertaking is well known, but no undertaking has been given to any court, let alone this honorable court. Therefore, there is no breach of undertaking, there is no disobedience. There is no order which has been breached. Therefore, there is no civil contempt. Now look at the same thing. But now kindly have a look at the averments in the petition. Now 1, 4 and 5, 6 and 7 have been added.
Yes.
There was NHPC efficiency.
They were added subsequently.
Yes,
Now kindly have a look at the contempt petition, my lords.
yes, yes.
One cause title, one is Gaurav Kumar, General Manager NHPC. My lords have noted it. Contemptor
Yes, sir.
number 1.
Yes.
4 is Sri Raj Chaudhary, contemptor number 4, Chief Managing Director NHPC. 5 is Lalita Kumar Tripathi, Executive Director of NHPC, contempt number 5. And 6 and 7 who have been added
At the replacement of these officers.
have the replacement of these officers. Give that order. Now look at the averments, my lords, of the petition.
Yes.
Now kindly look at para 3 where they have said the following orders have been passed. That has that order of 10th of February. Then para 4. The common judgment order dated, my lords have got para 4 of the
Yes, yes,
contempt.
got it. Got it.
Common judgment order dated 10th of February 25 was passed in the presence of respective counsels of all the contesting parties. In any case, the petitioners, after receiving the certified copy of the common judgment order dated 10th of February 25, immediately forward the same to the respondent authorities on 13th of February 25. More particularly, respond number 2 and 3. More particularly, respond, the emphasis on respond number 2 and 3 because they were to constitute the board. Herein, in the said communication, it was also urged to complete the entire process within a stipulated period of 3 months as provided by this honorable court in its judgment order. Additionally, Director Land Management on behalf of respondent number 2 issued a letter dated 6th of March 25 to respondent number 3 requesting necessary action pursuant to the judgment order dated 10/2/25, including constitution of board to carry out a land and property survey, prepare draft award and submit the same to the government. Thereafter, the petitioner also submitted a representation dated 7th of March 25 to respondents 1 and 5 herein, forwarding the letter and further requesting them to coordinate with the office of respondent number 3 to ensure the timely completion of the process of preparing fresh award. Copies of the my lords may see, what is the representation given to respondent 1 and 5? Respondent number 4 is not mentioned. For what? For cooperating for completion of the process award. Petitioners also attempted to participate in the assessment of the land and property. However, they were not permitted to take part in the survey. Then para 6, that when even after lapse of 75 days, petitioners were not taken into confidence regarding process, regarding what? Process of fresh award, and were kept uninformed throughout. They filed RTI application on 25th of April 25, seeking details of correspondence related to the award process. In response, documents were furnished to the petitioners. Copy of RTI reply. Then para 7. Upon perusal of the documents furnished in response to RTI, it was revealed that officials of NHPC had deliberately abstained from meeting of the board. It was further observed that respondent of NHPC remained unyielding throughout the process preparing the fresh award. Continuously insisted for previously determined list of 41 projects. So and so repeatedly sought for updated information regarding the number of families willing to opt for resettlement, asserting they would not be unable to proceed further without such data. So what is the allegation? We asked for data. Without that data, we will not be able to proceed with. Is it willful contempt? Is it contempt of? Is it that we said that award is to? We have said anything about the award? Nothing. But ultimately, time was extended and the award was passed. Therefore, this pales into insignificance. Now, this issue was never brought before this honorable court, nor does this fall within the purview of NHPC. Rather, it is an issue decided by the issue to be decided by the collector. Nevertheless, Deputy Commissioner Dibang had already forwarded a consolidated list of all 41 project affected persons, families who opted for resettlement at the RR site. Copy. Then, my lord, para 8, timely completion. Further perusal of RTI reply reveals that respondent number 2 herein has specifically directed respondent number 3 to ensure the timely completion of process for preparing fresh award and to forward the same to the government. Director repeatedly reminded respondent number 3 to strictly comply with the directions of the honorable court. In his most recent communication, Director letter dated 5th of May 25 requested respondent number 3 to submit action taken. However, respondent number 3 failed to comply with both the directions of the honorable court. So who has refused to comply? Respondent number 3, directions of the honorable court. Not a whisper so far that we have not complied with any direction of the court. And representation made by the petitioner urging timely completion process for preparation of the award. Then para 9, it is most humbly submitted that petitioners have been regularly submitting representation, communicating all the response herein requesting the timely completion of the award. They have repeatedly urged the proper coordination be maintained among concerned authority to ensure a smooth and timely conclusion of the award process. Pertinent to mention that earlier award was passed in the year 2008. However, the same is challenged by NHPC, could not be implemented due to pendency. Only after a long period of 6 years was the matter finally adjudicated. Now, despite directions from the Honorable High Court, NHPC and respondent number 3. So NHPC, not respondent number 1 and 5. NHPC and respondent number 3 are willfully delaying the preparation of fresh reward. Even with a clear mandate to complete the process within a stipulated period of 3 months, respondents failed to comply with the directions of this honorable court. That the RTI documents received a communication dated 28th of April 25 from respondent number 3 addressed to the government advocate of this honorable court seeking an extension of time from the honorable court for compliance with directions. The said communication reveals the delay in the entire process of preparing the award is attributed to NHPC. The evidence the NHPC officers under the pretext of seeking consolidation list of 41 projects of 41 project affected families consistently refrained from participating in the award preparation process. Respondent number 3 in the said communication also placed the entire blame for the delay on NHPC and the ground for seeking additional time to comply with the directions of this honorable court. So direction of this honorable court, constitution of the board and making of the award, they said NHPC was contributing to the delay. But anyway, the time was extended. Therefore, the direction of doing it within 3 months did not survive. That once the directions have been changed and extended and modified, there would be no contempt. Granting any further extension of time to respond for the compliance with directions of this honorable would only serve delay in the course of justice. Then 11, not para 11. Respondents contempt willfully failed to comply with the direction of honorable court and singly and severally directly played mockery with on the very face of the judgment order passed by this honorable court. That what can be drawn out of it is that the respondents are deliberate violation of orders of this honorable court at the behest of those involved in the commission of irregularity. There was a fit case wherein lordship said draw contempt proceeding against the respondents. As vague as anything. How we have done it, what we have done it, nothing. Then para 13, that is present case, a fit case where this honorable court may be placed to draw contempt proceeding against the respondent contempt singly or severally. Further, pleased to punish them under the provisions of the contempt of thus petitioner filed this petition. Not a whisper against any act directed against respondent number 1, 4, 5, 6, 7. That they have willfully done it. Only vague, general allegations, ambiguous allegations that we have delayed the drawing of the award. Where is it that the award has been passed? You have not paid, therefore you have committed contempt of the order of 10. Not a whisper in the entire petition. This is a frivolous, vexatious contempt petition, should be dismissed with cause. Now, there are some judgments which I have cited in my first written submission for it. That is first written submissions, short note, dated 25th of March 26. Roman 5 at page number 5, para number 30. Contempt, the title is Contempt Proceedings cannot be converted into execution proceedings. My lords have got it?
Yes.
Contempt proceedings cannot be converted into execution proceedings. It is expected to submit the payment or disbursement of amount quantified in the award was neither a subject matter of judgment dated 10/2/25, nor can be brought within the ambit of present contempt proceedings, which are instituted solely for alleged non-compliance with direction to pass an award within the stipulated time. The settled position of law is that contempt jurisdiction cannot be invoked for enforcement of monetary claims or for seeking execution of a determination. Present attempt by the contempt is nothing but an effort to convert contempt proceedings into execution proceedings, which is impermissible in law. According to present contempt petition, insofar as seeks disbursement of the award amount is wholly a misconceived and not maintainable place reliance of. But even the prayer is not to make a disbursement. Now, belatedly, they're making an oral request. And application filed after 8 months. First judgment, R and Day Malos versus Bhagyapati Pramanik, 2004 SCC 400. We may read that weapon of contempt is not to be used in abundance or misuse. Normally, it cannot be used for execution of a decree, nor implemented order for which alternate remedy in law is provided. I'm only reading the marked portion, underlined portion. It is also noted that under the coercion or contempt proceedings, appellants cannot be directed to pay a compensation amount which they are disputing. Then second is Anil K. Surana, the highlighted portion. Directions to pay installments can at the best be treated as a decree. We hold that by consent of parties, an executable decree was passed in favor of the respondent bank. The remedy of enforcing decree can only be by way of execution proceeding. Thus clarifies it will open for respondent to take out execution proceeding. In our view, contempt proceedings were not the correct remedy. Therefore, set aside the impugned order to the extent that it punishes the opponents for contempt and sentences them as stated above. Then Kapil Dev Bihar, holding the respondents have committed contempt, civil contempt, and that it has to be shown that there has been willful disobedience of a judgment or order of the court. Then my lord Muhammad Iqbal, court judgment. From the above, it appears that appellants were expressing his genuine difficulties with regard to the implementation of order dated 21st of September 22. Such a situation insists on the court when implemented may not square with the realities and situation, the practicalities of implementation of the court direction. Now considered view booking a party to contempt proceedings and enforcing obedience to such orders hardly lends credence to judicial process authorities. And last one, Chadurganga. Last, particularly what the order by means of a contempt proceeding seeks is an execution which cannot meet with our approval. Then Chardunga, the weapon of contempt is not to be employed for execution of a decree and for implementation of an order when an alternative remedy in law is available. That is execution. Similar are the judgments, but there are so many other judgments. So I'm not bothering taking time of the court. Now, my lords, they have converted contempt petition into execution proceeding, which should not be allowed. Now, my lords, may kindly have a look. What is the allegation specific to respond numbers 1, 4, 5, and 6 and 7? That they have individually, willfully disobeyed any direction or order. Merely because you're a managing director, merely because you're a director, merely because you're an executive officer, it cannot be implied that you have willfully disobeyed any order. Assuming that there is such order, I'm not arguing that there is any such order. Assuming that there is any such order, where is the averment that this person was supposed to comply with it and he has not complied it in such a manner? Nothing. So even though no specific instances as far as 1, 4, 5, 6, and 7 are concerned, and 4 and 5 been substituted by 6 and 7. If 6 and 7, I am subject to correction, my lord, if my instructions are correct. If 6 and 7 are substituted, 4 and 5 is substituted by 6 and 7. Then a contemner can be substituted is something which I'm, unless you by mistake made him a party. That's not the case. What does it say? Why has it been substituted? Show me that order. This is implement application. Just give me a minute, but I'm so sorry. I don't have an implement application, therefore I'm sorry, but there can't be an implement substitution.
270 is the
Okay.
270 is the there can't be an implement of an application. What is the date of an implement? So my submission is, you can't substitute somebody and somebody else is responsible. Therefore, originally 4 and 5 are not responsible. I don't understand. But I'm sorry. Since I don't have the implement application, is there? Now, kindly have a look at the order of 10 of November 25.
This is passed in IA 270 of 2000.
IA 270 of 2025.
Yes.
Now, kindly have a look at that or now. But no reason why they have been impleted, my lord. Only because earlier people have superannuated and gone, shifted to other departments. Therefore, how can they be impleted? In a contempt petition, it is person specific. Your success, if you have committed contempt, your successor, it is not like a civil suit where successor is implicated as a party. Unheard of. Your person has committed contempt. Even if he has left the office, even if he has been transferred, his successor can't be hauled up for contempt, for disobedience. Therefore, there is no contempt. And there are no allegations how respondent number 1, 4, 5, 6, and 7 have committed contempt. Therefore, on this ground also, the petition requires to be dismissed. This is all that I have to submit as far as the contempt is concerned. I'm thankful for a very patient and hearing, my lords.
Okay. In respect of the writ petition?
Yes.
Yeah, they have to be. Give me some time, because I'm required in some matters. I'm busy.
I will give a reply both. Let him argue on the writ petition why it is maintainable.
Contempt may be closed. Thereafter, I'll apply. I'll argue on writ.
That's what they this is the main.
It's a separate cause of action. I am not today.
Why there is a writ petition and my learned friend is making some
On the last occasion, Mr.
with great
Das,
respect,
said,
some ridiculous
let us hear the
argument.
contempt petition. I am not insisting for the writ. Now today you are saying let it be heard together. On the last occasion, if please recollect your
Yes,
words.
it
You
is
said
fixed.
I am
Today-
pressing the contempt petition. It may be heard later on.
No. It has been fixed together. Maintainability also has been fixed because writ petition is fixed. Why they are avoiding the writ petition, I don't know, my lord. They are
Because I'm
avoiding the writ
required in some
petition.
other matter. I'm required in
They
some other
know.
matter.
But I will argue, my lord, why it is not maintained. First, let me give a reply to my learned friend what he has argued before the court.
Okay.
My
Yes,
colleague
I'll
is here,
just
my
give.
lord. May I go, my lord? I'm called in the Supreme Court in some matter, my lord.
Yes.
May I just go?
Okay.
Yes. Okay. My lord, just before my learned friend Raju leaves, I just pray before this honorable court that my learned friend argues the matter tomorrow itself, my lord, so maintainability is concerned.
But
Why
he
writ
can't-
petition?
I'm sorry, my lord. He can't fix he can't decide. Why does he
I am
insist
not
that I should
deciding. I am not deciding. I am
You are
not
not the
deciding.
presiding court, sir. With
No, I am
great
not a
respect.
presiding court. I am not a
You can make a
presiding court.
request to the court,
Yes,
but you can't say that I
that's
should
what
do it.
I made a request.
Okay.
Request. My lord,
Any
I'll just
date
give
other
a,
than tomorrow may be given, my lords.
I will just give a reply to my learned friends. What he's saying ultimately that there is no undertaking given by NSPC, their officers or the contemners. This is what he's saying. As because on 10th of February 2025, when the judgment was passed by this court, my lord, there is no alleged breach of this order, so far as those NSPC officers are concerned. That's what he's saying. 10th of February 2025, if your lordship recollect the para 23 of the judgment, that was an undertaking, some type of statement submission made before the court by the learned counsel appearing for NSPC, who is representing the NSPC. He said, your lordship will clearly remember that is a submission which has been made. We are agreeable to pay as per Lara Act. I said, yes, if you are agreeable to pay as per Lara Act, we are ready to accept it. That is the inducement which was made. That is why your lordship has passed that order. The following direction was passed. Now, what he is saying that how can you come to the court because the award was passed on 1/8/2025, your contempt application has been filed on 14/5/2025. 14/5/2025, you have come before this court only for the purpose that the government is not constituting the board and they are not reassessing the award in pursuance to order that has been passed on 10th of February 2025. I'll give two replies. First reply is that what is saying that there is no undertaking which is given NSPC or by the contemptor or by the officer. I disagree to it, and my reply is followed by a judgment of the Supreme Court. It is not necessary. My lord will please see the judgment 2023-17 SCC 545. A new judgment, my lord. New judgment.
Today
Yes.
you are submitting.
Yes, that's why I'm submitting. Kindly see para 59. This is also a contempt, my lord. Para 59. May I read, my lord?
Yes.
The Bombay High Court in so and so took notice of a practice wherein the undertaking would not expressly mention that it was given to the court, but the High Court took cognizance of the fact that the expression undertake had come to acquire through long practice a technical meaning. So and so High Court speaking, the clause does not state to whom the undertaking is given, and it may be that it would not be possible to hold that as the parties were settling the dispute between themselves, the undertaking was given by one of the party to other, or at the highest, the only thing that could be urged would be that the expression is ambiguous, and in a contempt matter, unless the court is clearly satisfied that the undertaking was given to the court would not proceed to commit that person in default to jail. But in our opinion, expression undertake has come to acquire through long practice a technical mean in all the orders and decrees of the court. Whenever the expression of party undertakes has been issued, it has always borne the meaning that an undertaking has been given to the court. The Advocate General has also referred to us the forms and orders so and so, and in this form, expression use has always been a party undertake and never a party undertakes to the court. Therefore, in English court as well as the expression a party undertakes when used in decrees or order has come to acquire the same technical meaning. What is more, it has held by Bhagavati J an opinion with which I entirely agree, that it has been the long standing practice on the original side. Whenever counsel wishes to give an undertaking to the court, he never expressly used the word to the court, but merely states that he undertakes on behalf of his client, and that undertaking is always understood to be an undertaking to the court which could be enforced by a committal proceeding. Now, my lord, pausing for a moment, what was the order that was passed on 10th of February 2025, my lord? Paragraph 23. I'll just trouble your lordship so that it will be easy to connect. What was the undertaking? It is a form, a commitment which was given by the court. Only on the basis of that following orders were passed. I'll not trouble because your lordship has seen 100 times we are showing and troubling the court that para 23. Your lordship remembers that para 23 also, my lord. Because that's why one judgment of the Supreme Court was shown. I'll show again, my lord. Your lordship, why that following orders were passed. Subsequently, that direction was given to them on the basis of paragraph 23. And my learned friend, Mr. Tiwari, has said that only because of on behalf of his client, he said, I cannot say something of my own. It is I am representing my client. Your lordship knows that I am representing my client. Whatever I say on behalf of my client. So on that day, he said that yes, because he got instruction from the client. He understood that this is a case where it is a private land. If it is a private land, that yes, it is covered under the LARA Act. Though they are entitled to get compensation under LARA Act, minus they are not entitled to get 25% of net present value, which your lordship rightly hold, because it goes to a community, it goes to a clan. There is no diversion of land. Only what they will get, benefit under LARA Act, and also the RRN policy, where the PF police has to be shifted to the particular portion of land which has been identified. That's what your lordship has said, 25% you are not entitled to it. On the basis of that, we agreed before the court. So that's what type of undertaking has been given by the court. The judgment, the last occasion where I showed my judgment of this court, even if there is no undertaking, an inducement has been made, on the basis of that the court has proceeded, then also it is liable to be contempt. My lord, my learned friend has said, that contempt, you please see what he is saying, that contempt, my lord, violation is judgment as a whole has to be read. Is not one paragraph. He is reading, my lord, paragraph after paragraph 23, my lord. He is reading those few, my lord, 5 direction which was passed by the court. Why your lordship has passed this direction? 1, 2, 3, 4, 5, 6. It has to be reassessed. Assessment has to be made. Constitution of board. In what manner you have to calculate? 29 has to be followed. 12% interest has to be paid. And within 3 months it has to be done. And we came to the court. That within 3 months you could not comply. We have come to the court on 14/5/2025. Respectful submission, what my learned friend is saying, that there is no contempt against them. There is no contempt against them. They said, if at all there is a contempt, there can be a contempt at best R2 and R3, which is the state government. Ultimately, end of the day, after the contempt was filed before the court, the board was constituted and the assessment was made. And the award was passed on 1/8/2025. Now, to the extent of undertaking, please see, my lord, page para 71 again, my lord. Please see para 71 of the judgment. 71 to 74, my lord. 71. Lordship got it?
Yes.
We go back to the order passed by the learned single judge of the High Court dated 14/10/2015 in civil application number in special civil application recording the assurance undertaking given by learned counsel on instruction from his client that the property with respect to the subject matter of the disputed entry would not be sold till the disposal of the main petition. The order reads thus so and so. It is stated at the bar says so and so on instruction from his client, property qua the subject matter of this entry and the petition shall not be sold out till the main petition is heard and decided which satisfy the conscience and so and so. Hence, this civil appearance shall dispose of. It goes without saying that the order was passed at idem by consent of learned advocates. 72. Having regard to the principle of law as aforesaid, it will be too much for this court to say that the statement made by the learned senior counsel before the High Court was just an assurance given to the court to the lease and was not an undertaking given to the court so as to entail the consequence of civil contempt. Now see 73. It is true that every undertaking given by a party to a litigation may not be an undertaking to the court. There is a difference between an undertaking given to the other party and an undertaking given to the court. The breach of undertaking given to the other party may not constitute the contempt of a court. However, when a particular undertaking is an undertaking to the court or to the opposite party, must depend upon the facts and circumstances of each case and the language used. In the case on hand, it is not the case of the appellant that they have settlement with the other side outside the court and reported the same to the High Court, and the High Court proceeded to pass the order incorporating the undertaking given by the learned counsel upon instruction from the clients. Even if the parties have negotiated a settlement outside the court and reported the same to the court, and the court have passed an order in terms of such undertaking, there would be no scope to warrant that undertaking was not given to the court. My lord, this become a worse situation. This become a worse situation where party compromised the matter outside the court and said this is here, comes to the court and said that this is a compromise which has been made and this is an understanding between the parties. This is the worst. But here is a case where in the course of argument it was put forward before the court. Am I clear, my lord? Here. Now please see 74. An undertaking or an assurance given by a law based upon which the court decides, this is important, upon a particular course of action would definitely fall within the confines of undertaking as stipulated under section 2B of 1971 Act, and the breach of which would constitute civil contempt relied upon by so and so. And if a party or a solicitor or counsel on his behalf so as to convey to the court a firm conviction that undertaking is being given, party will be bound, and it will be no answer that he did not think that he was giving it or that he was misunderstood. The breach of an undertaking given to the court by a person in a pending proceeding on fate of which the court sanctioned a particular course of action is misconduct amounting to contempt. My lord, what more it requires, my lord? And please look into 117, that is page 604, my lord, summary 604, 117. 117, my lord. We may, what you got it? Page 604, 117.
Yes.
We may summarize our final conclusion as under 117.1. We hold that an assurance in the form of an undertaking given by a counsel advocate on behalf of his client to the court, the willful breach or disobedience on the same would amount to civil contempt as defined under section 2B of 1971 Act. Now 117.2, there exists a distinction between undertaking given to a party to the lease and the undertaking given to the court. The undertaking given to the court attracts the provision of 1971, whereas an undertaking given to a party to the lease by way of an agreement of settlement or otherwise would not attract the provision of 1971 Act. In the facts of the present case, we hold that the undertaking was given to the High Court and the breach or disobedience would definitely attract the provision of 1971 Act. Now, the argument that is advanced by the NSPC is that only he is reading the direction, the 5 points which the ultimate paragraph, only because of para 2023, where your lordship, the counsel on behalf of the NSPC has represented and he has given a one sort of an undertaking before the court. Otherwise, there was no occasion to pass that direction, my lord. We agreed, both parties agreed, the court said, okay, you agreed, now this is the direction which has been passed. So now if an undertaking given to a court and I agree to it, that will be amount to a civil contempt. Now my learned friend can't say that he is 23, he will not read, he will read the other. So judgment as a whole, we have challenged it. Now the question comes here. He said that no, the award was passed on 1/8. That's a major argument. So 1/8/2025 is the award pass. So how can you now, that's a future, event is future, my lord. You come to the court on 14/5 and that time the award was not passed. So where is a question of a contempt? This is what he is arguing, my lord. I have come to the court for fully compliance of the court's order. It is a fact that in a contempt, in a land acquisition matter, my lord, it is only compliance of the state. There is no compliance of the requiring authority. That's not the intention of the LA Act, my lord. That I have shown, my lord. The manual also, the LA Act also said it is not one-sided. You make a request to the state to acquire a land. The state acquires. Now, thereafter, requiring authority has to deposit. You don't deposit. If they doesn't know what is land acquisition. My lord, they are the biggest corporate in India, and this is not the first case. How many cases I can give instance of NSPC, my lord? Instance, they said NSPC, your lordship knows how many projects they are doing it. Only for the purpose, I say, I am not saying to my learned friend, it is only for the purpose that somewhere some ego is there, that's why they are not paying it. That's the reason why they are circumventing the order of the court, only to file a writ petition before this court. And your lordship will be shocked. Your lordship will be shocked after going to a writ petition. What they are saying? Denotify. The entire land denotify. Now, what prevented you before the learned single judge was adjudicating the matter to raise those particular points? You never raised those points. Now, my lord, I will show my writ petition. Yes, well, my lord, just one, sorry to trouble, one, because my learned friend is saying something that there is not required, because your whole case is contempt against the state, R1 and R2. You cannot drag them. Now, I will just trouble your lordship, which I have shown already. Two judgments to the point. This is 2024 SCC online. Last time, your lordship. 2024 SCC online, SC 3727.
Yes, got it.
I will just connect with an undertaking. Now, in this case, whether specific direction is required or not. That's the point, my lord. Whether a specific direction is required. Because my learned friend all the time is saying that there is no specific direction given to the NSPC. Please see 192, my lord. 192.
Yes.
It was observed that even if the parties have not filed an undertaking before the court, but if the court was induced, this is so important, but if the court was induced to sanction a particular course of action or inaction on the representation made by a party, and the court ultimately finds that the party never intended to act on the said representation or such representation was false, party would be guilty of committing contempt. My lord, what more, my lord? If there is no undertaking given by the party, but some type of representation has been made, as has been made in para 23, that will also amount, because otherwise there is an inducement and your lordship has act on it. That will amount to contempt, my lord. Now, my lord, 199, kindly see, my lord. 199. No specific direction is required. As my learned friend is saying, that should be a specific direction. See 199. The law of 2008, 2004 has drastically changed, my lord. See 199, my lord. The contempt jurisdiction of this court cannot be construed by any formalic or rigid approach merely because there is no prohibitory order or no specific direction issued. The same would not mean that the parties cannot be held guilty of contempt. The contempt jurisdiction of the court extends beyond the mere direct disobedience of explicit orders or prohibited direction issued by the court. Even, my lord will kindly note, even in the absence of such specific mandates, the deliberate conduct of parties aimed at frustrating the court proceeding or circumventing its eventual decision may amount to contempt. I'll pause for a moment and I will submit humbly before the court only for the purpose of circumventing from 1/8/2024 till date. My lord, they have not complied. Today they are saying we have complied. What you have complied? You complied because you filed a writ petition before the court. The court, my lord, at the very first instance was not inclined to interfere with the order. Then thereafter said that what remains, what is there? It is a consent of the parties. My lord, that is what has been reflected in the order. It is a consent of the parties. On their submission, we also said that, okay, deposit the amount before the court. If you want to deposit the amount in the court, only for the purpose that writ petition would stay. Otherwise, on that day, writ petition would have been dismissed on that ground. There was no stay of this order. That order has not, indirectly, what they want, indirectly they are challenging the whole judgment of the court. 10th of February 2021. Otherwise, what would be your case in the writ petition? My strange enough, your writ petition case was that bringing all those denotification, saying you are not entitled to land to land. How can you blow hot and cold at the same time? What stand you had and what stand you have taken in the writ petition? What is that? It is only for circumventing the court's order. And a false representation was given before the court. I am not blaming my own friend It is true, their NSPC said, okay, we are agreeable. And these landowners, my lord, from 2018, they are fighting the battle. They can't do anything. They can't do anything, so they have come very smartly by circumventing the order and they file a writ petition to show, look here, this is what we are going to, we are challenging this. But so that what this part says that or circumventing its eventual decision may amount to contempt. This is because such actions strike at the heart of the judicial process, undermining his authority and obstructing his ability to deliver justice effectively. The authority of the courts must be respected not only in letter of their orders but also in the broader spirit of the proceeding before them. Now 201, my lord, kindly see. 200, my lord. Any contemptuous conduct of the parties to bypass or nullify the decision of the court or render it ineffective or to frustrate the proceeding of the court or to inure any undue advantage therefrom would amount to contempt. Attempts to sidestep the court jurisdiction or manipulate the course of litigation through dishonest or obstructive conduct or malign or distort the decision of the court would inevitably tantamount to contempt, since any prohibitory order or direction to such effect. 201, 205, my lord, will kindly see last. Now, this is the last I am showing the paragraph. Where a decision is rendered and the impugn order is set aside, it behoves any logic that an express direction to act must be given in respect of every aspect of the decision. This paragraph, parties are duty bound to act in accordance with common sense. My lord, I am respectfully saying they doesn't have a common sense of what, my lord, that once it is acquired, they have to pay. This is a common sense, my lord. You have to pay. Where is a question of a specific direction to be passed by the court? It is implied. It is, that means what they are saying. All the matters your lordship will adjudicate, there has to be a specific direction by the court to pay by the requiring agencies. That is not the intention. LA Act, your lordship knows thousands of cases your lordship is adjudicated. Automatically. It is, that's why Deputy Commissioner written letter to them. That's what your lordship, I have shown your lordship, recollect. He has said, NSPC said, that is why when the matter came up before the court, a court was annoyed, saying that what you are saying, I'll show that order, my lord, that order has been read, that this amount to contemptuous. Your officer said that no, we want a specific direction from the court, but then we will comply. What you want, a specific direction from the court, it is implied. Deputy Commissioner writes back to them, it is implied. They said, once I get an order from the court, we'll deposit the entire amount. We'll deposit the amount. Where is the question? That's why the court, while passing, when the matter came up, the court, this is absolutely contemptuous. How can you do it? A direction, then the court said, Father, what do you want to do it? Your awards, challenging an award will be on very limited ground. Very limited ground that the court has spelled out, your lordship has seen. Very limited ground your challenge will be there. Then what the council said, no. We will come out and we'll comply, we'll be compliance, we will comply. Then what happened, my lord? Ultimate end of the day, in the month of February, they did not comply and they filed a writ petition before this court. This is what the judgment says. You cannot circumvent the court's order. See, kindly see 205. The parties are duty bound to act in accordance with common sense. It is axiomatic that a party should obey both the letter and the spirit of a court order, and it is neither open for the parties to adopt a myopic and blinkered view of such decision nor any such interpretation or view that subserve their own interests. It is ultimately the purpose for which the order was granted that will be lodestar in guiding the parties as to the true effect of the order and determination of the court. 206, my lord, if at all parties are in doubt over the judgment and order of this court, the correct approach is to prefer a miscellaneous application for seeking clarification rather than proceeding to presume a self-serving interpretation of the decision. I'll stop that, my lord. The basic was 205 and those paragraph, my lord. Now, what is saying, my learned friend is saying, how a third party is liable? These are new parties, new officers, so they are no, they were not a part in that, so how they are liable? I'll show one judgment to this effect, my lord. Last time we have already have submitted 2026, my lord. (2026) SCC online SC 322.
Yes.
Para 21. Liability of third parties. Non-parties for contempt. Lordship got it? It's 21, my lord.
Yes.
Yes. 21. Before resting the pen, we are duty bound to indicate as to how the third parties, non-parties to the original proceeding can also be proceeded against for contempt. This question has cropped up before this court in the past. We need only cite the leading judgment on this point. So this leading judge, para 23, my lord, will kindly, judgment was cited. Now 23. Simply put, para 23, my lord. Simply put thus, it is no longer res integra that a party once become or is made aware of an order of this court, if yet acts in willful default or deliberate non-compliance or any such like conduct against in breach of the order concerned, makes itself liable to face the full wrath of contempt jurisdiction. In the cases at hand, the government and the additional chief secretary have been ever so and so is not necessary. Now, my lord, I will just show IA 304, my lord, in this connection to connect their maintainability point, their maintainability. Please see their application maintainability 304, that why it is not maintainable. GM has been a party from the start. See para 13, my lord. Lordship got it? Para 13. 13, 14. It is regarding CMD. Because CMD had changed, that's why, my lord, they have come up. Para 13. The significant administrative reshuffle at very senior level of NSPC created difficulties in taking a final decision on the matter. During the pendency of the contempt petition, erstwhile chairman and managing director, Sri so-and-so, who was aired as respondent number 4 in contempt, retired from service on attending the age of superannuation with effect from 30/6/2024. 5. And was succeeded by Sri Bhupender Gupta, who assumed the charge of the post of chairman and managing director, so-and-so. That is why, my lord, we have replaced. But we replaced earlier. Now see 14, that likewise, see so-and-so, who was aired as respondent number 5 in the contempt petition, was subsequently transferred from Dibang Multipurpose Project by order dated 30/9/2025 and was replaced by Narendra Kumar as Executive Director of Dibang Valley. Sri Narendra Kumar assumed the charge of office of so-and-so on 28/10/2025. So GM was the party throughout, since earlier itself, GM of NSPC. So GM is aware of it. It is not necessarily all the party. GM is aware, he is representing NSPC, my lord. Now please see, my lord, my learned friend is saying the contempt you have filed on 14/5/2025. 14/5/2025. But they said that where is the question? Your contempt is only confinement that this has been strict, has been obeyed, because in pursuance of court's order, committee has been constituted and the respondent has taken the action by reassessing and awarding the award. Now, after that, my lord, on 1/8/2024, we filed, after 1/8, we filed an application additional affidavit bringing notice to the court. It is not necessary I will file another contempt, my lord. In that contempt, I file an additional affidavit bringing notice to the court. That is, my lord, 1/11/2025. Please see my additional affidavit. Not necessary that I have to file another contempt.
Additional affidavit dated?
Dated, my lord, 1/11/2025.
Where you have filed this additional affidavit, in which matter?
In the contempt itself.
In
my
the
lord.
contempt.
In the contempt. Page is start from page 162, my lord.
In this process, after every step you find the new contempt.
Para 162, lordship got it? Additional
Yes,
affidavit.
got it.
To bring certain facts and documents on record, my lord.
Mm.
Now, paragraph 11. Please see paragraph 11, my lord. That consequent upon a delay of the NSPC authority, an online RTI application was filed before the PIO. NSP for seeking information regarding the compliance of the Honorable Court's order, status regarding the deposition of award, reason for delay, etc. As per serial number 1 of the reply, NSP authority has admitted the fact that as per Honorable High Court judgment dated 10/2025 by adequate representation in the Constitution Board by Constituent Board was complied by them is actually partial compliance, has clearly directed not only adequately represent but also disburse the compensation amount within a period of 3 months. So it will include, my lord. My lord, that or it is implied. Now please see the RTI. Please see the reply, the RTI, which we have made at page 200. Please see 200, my lord. RTI which we made.
Yes.
1. Now, furnished whether WPC 242 and so on has fully complied or not. Their reply, my lord. Honorable High Court by judgment so and so for necessary compliance which included constitution of a board with adequate representation of NSPC. Now, NSPC as a board representative has complied the required direction. Now, please see number 2. Status of letter dated 1/8/2025 regarding deposition of RR side so and so. The proposal regarding release of the compensation side is under consideration of the competent authority. So, my lord, it is not a case where they are saying that no, your what remain in your contempt. We brought this contempt by filing an additional affidavit in this contempt. What happened thereafter? So they cannot escape and they cannot say, no. This is, your is premature contempt. That's why it should be closed. This is what we made a RTI. And they said, my lord, is under consideration of the competent authority. Now, my lord will kindly please see 187A. Please see 187A. Again, I am troubling on 29/7/2025 before passing of the award.
Page number?
Page number 187A on the same, this additional affidavit.
Yes.
Please see this letter on 29/7/2025 by the director, executive director to the deputy commissioner. See paragraph 4, my lord. Honorable High Court has not directed to deposit any compensation at this stage. Deposit of compensation amount by NSPC and subsequent disbursement may be considered only after passing of any order by the Honorable High Court in the matter. In view of the above, it is submitted upon receipt of final revised award and further direction from the Honorable High Court in the matter, NSP has taken immediate steps for deposit of compensation as desired by your office, letter dated 29/7/2025. We assure of our continued commitment in complying with all the legal direction and statutory requirement. Now thereafter, my lord, on 1/8/2020. Para 12, my lord, kindly see. At page 169, my lord. See para 12,
Yes.
my lord.
Yes.
It is humbly submitted as per the Honorable Court's order dated 8/9/2025 in the instant case where the petitioner was directed to take steps upon response 1, 2, 4, and 5 was duly complied and the same were acknowledged by postal certificate dated 22/10/2025 issued by Sub Postmaster Rowing. Furthermore, it is respectfully submitted since the revised award was approved by government and duly informed to the respondent number 1, 2, 4, and 5 by letter dated 1/8/2025. It has been more than 3 months and still the aforesaid authorities are deliberately keeping the petition in dark for illogical reasons while delaying the whole process. And we brought it by this at page 202, my lord. 202 and 203. See 202, my lord, certified that so and so from sub postmaster, so and so has been delivered to the addressee as per office records and status available website of so and so. The acknowledgement card of so and so returned to the sender. Tracking and record of the same is not available, so and so. So now second, my lord, again it has been GM, my lord, GM appeared, my lord, and 203, my lord, it is to ED, Executive Director. Now, my lord, your lordship has seen this again. It was served to ED, has been delivered. Intentionally, they were avoiding. Then thereafter, I'll just give a compilation and we give to my learned friend the order, copy of the order only. Compilation of the order of the High Court's order. In contempt, my lord. This is record, my lord. It's nothing new, my lord. So it becomes easier. Hey, other side of the yes. These are orders of the court, my lord. Now, so please see at page 22, my lord. 10/11/2025. After the additional affidavit.
Yes.
After the additional affidavit was filed. Mr. Das, learned senior counsel so and so, also heard Mr. Tiwari, learned senior counsel assistant by so and so, responded during pendency of the connected contempt case. The officials who were then holding the post of DC so and so and the executive director NSP has been transferred and a new incumbent have joined their respective posts accordingly. By filing this IA, applicant is seeking for imprisonment of the officials who are currently holding the post mentioned above. On query of this court, learned senior counsel for the applicant has submitted initially when the contempt petition was filed, a fresh award in terms of the order passed in so and so was not passed. However, during the pendency of the contempt petition, fresh award has been passed by DC so and so. Therefore, from the stand taken by the applicant, it appears the new incumbent to the office of DC, Lower Deeming Valley so and so is no longer in contempt. No order required to pass in so and so. According, no order required to pass. Para 7. In respect of the prayer for impleadment of the new incumbent number 7 and 8 are concerned, state respondent allowed to be impleaded as contempt number 6 and 7 as narrated in the cause title of this IA as well as paragraph 4 of this IA. So as in pursuance of the order passed by the court, we have impleaded. And your lordship knows the liability of a third party. In that case, they are also liable for contempt. Now, my lord, forget about all this. What about GM? General manager was appearing throughout from the very beginning, my lord. These are new officer. What about him? He is representing the NSPC, my lord. He could have informed the court, my lord. Now, my lord will kindly see. please see the order. Why the executive director, page 66, kindly see, my lord. Please see page 66. Order of 4/2/2026. Please see at page 69, my lord. 69, Lordship got it?
Got it.
Yes. Page 71, my lord. The judgment at page 70, kindly see page 70. The court, after hearing the contest, has disposed of both the writ petition, relevant part of which is extracted. So 23 paragraph was quoted, my lord. Lordship got it, my lord. Then thereafter, my lord, kindly see at page 71. It is the case of the petitioner, though there was a direction for constitution of a committee of the state and NSPC, the same was not done according to present petition for contempt was filed. The same was followed by filing of 2 IA by the state, being IA number so and so and the IA number so disposed of, while order dated 10/6/2025 by granting further extension of 2 months for compliance or direction. Finally, by the communication dated 16/7/2025 made by Deputy Commissioner Lower Dimang Valley, appropriate land management department of the state was forwarded with the aforesaid award, which was approved on 28/7/2025. NSPC Limited has, however, issued a communication on 29/7/2025 from which it appears that a particular officer was under impression that a further orders are required to be passed for disbursement of the amount in question. The said officer has been arraigned as a respondent number 5 in the present proceeding. Office note, however, reveals there is no uncertainty regarding service upon the said respondent number 5. Mr. Tiwari, learned senior counsel who appears for 3 of the officers of NSPC, has, however, submitted communication dated 29/7/2020. That's the letter, my lord, which I have read. Appears to have been issued with a wrong understanding of law, which, however, is without any malafide. He has submitted there may be a good ground for challenging the present approved award dated 28/7/2025 for non-compliance of certain provision of the right to fair compensation and transparency in land acquisition, so and so. So this court is, however, of the opinion that the final approval of the aforesaid award was given by the government way back in July 2025, pursuant to a judgment which was passed on 10/2/2025 on extended period of time. Almost 8 months have elapsed since such approval. In the backdrop of the aforesaid development, issuing the communication dated 29/7/2020 appears to be contemptuous on the face of it. Now, my lord, kindly see, Mr. Tiwari has submitted that some time may be granted to have appropriate instruction with regard, please take steps taken for compliance of the order in question. Learners has submitted, then so and so, so and so. Last is, my lord, be that as it may, as an exceptional circumstances, the court grants time to Mr. Tiwari, learned senior counsel, to obtain necessary instruction. Please let this case be listed on 18th of February 2026. And 16/2/2026, they file a writ petition before this honorable court. They did not come to the court and they said, my lord, this is what is happening. Straight away, they did not comply with the court's order. And in spite of the order that has been passed by this court, and with regard that the council said that the compliance for the order in question for next date and exceptional circumstances, we are granting you time. Till, my lord, 18/2/2026, they came to the High Court on 16 February 2026 by filing this writ petition. And indirect manner, they want a stay of the order. Stay of the entire order. Because I will read the prayer. I will read the prayer of their writ petition. In the end, I will read it. What is their prayer in the writ petition? So, and IA 304 Their maintainability, what they are saying now, Milo, see the maintainability. There's IA 304 of 2025. This has been filed on 2/12/2025. It starts from page 1. It starts from page 1. Paragraph. Para 11, kindly see, Milo. Para 11. Para 11. That it transferred a copy of the aforementioned letter of Director Land Management Government of dated 28/7. This is filed on 8th of December, Milo. 2/12, Milo. 2/12/2025. This is filed. So and so. Enclosing therewith copy of draft award was conveyed to the then Executive Director so and so by the office of so and so by letter dated 29/7, asking him to immediately deposit amount of 48.45 crores as per revised award. It is pertinent to mention that DC, instead of sending the copy of final award, NHPC sent the copy of the draft award to NHPC. Be that as it may, the then Executive Director Devang Multi-Purpose Project so and so, who was aired, instead of asking for copy of final award, responded by communication dated so and so, informing the DC that such deposit compensation by the NSP is subject to appropriate, kindly see, direction of this honorable court. That they want a direction, the explicit direction by this court. Such a response, my kindly say, presumably was based on the understanding of Respondent 5 that the Honorable Court in the judgment ordered only directed for the preparation of the award within a given time frame without any further direction for NSPC to comply with the said award within the said period of time, so and so, so and so. Now, what they are saying, my lord, they are saying that we will deposit subject to further direction of the court. The understanding is only based that presumably it was based on understanding. The Respondent 5 has directed only for preparation of the award. See para 12. See, my lord, they received the award on 4/8/2025. It was received in the office of the head project on 4/8/2025. Same was examined and file was forwarded for consideration of the award and scrutiny of the same to the head office of NSP Faridabad, Haryana. Now, my lord will kindly see, order the award 1/8, 4/8 was there received and they are sitting idle. One after another, the court passes an order. Your lordship has seen the order. They said, okay, we are going to comply with the court's order. And compliance, you said, on a limited prayer, we are giving you time. And the next date is fixed on 18th of February 2026. There are several orders, my lord, only to purpose that they will avoid this entire contempt application, only for the purpose of avoiding the court's order. Now, this is what they say. See paragraph, my lord, 18, kindly see, my lord. See paragraph 18, which is contrary to the judgment that we have shown, my lord, that the law is well settled to make out a case for contempt of any order or direction of the Honorable Court, only such direction which are explicit in a judgment or order or are plainly self-evident ought to be taken into account for the purpose of consideration as to whether there has been any disobedience or willful violation of the same. Paragraph 20, that the final award is presently under active consideration. Please see this. At the highest level of NSPC, an appropriate decision on the same will be taken within a reasonable period of time. Applicants are conscious of their duties and responsibility and will take appropriate decision on the implementation of the award within a reasonable period. However, it is expected petitioners should refrain from using the contempt jurisdiction of this Honorable Court against the applicant as a mean of coercion and intimidation for compliance of the final award. They never spelled out in their any of their application that in a contempt proceeding they will pay this amount of 48 crores within this period of time. There is no, they are what they are saying all the time. There is no direction passed by this court to pay the compensation amount. Once we get a direction, we'll pay the amount. This is what they are saying, my lord. That is why the court, when it is amount to contemptuous on the face of it, how can you say it is implied direction?
No, no. While both the writ petitions were disposed of,
Yes.
where the court will pass the order?
I'm sorry.
Where the court will pass the order?
Yes.
Where the court will issue such direction while already both the writ petitions were disposed of?
Yes. Your lordship has disposed of 10th of
Yeah.
February 2025.
Yes.
They have to pay. It is implied.
Okay.
My lord, what I am saying, my lord, it is implied.
No,
They
all
can't,
right.
my lord, it is not a one-sided that they will only, state will do and you will not pay the amount. Because there is no question of any
No, no.
direction.
Mr. Das, you see, the learned counsel
Yes.
for the NHPC, Mr. Tiwari,
Yes.
on that day,
Ah.
assured before the court that we are agreeable to pay compensation to the project affected families, provided the same is assessed under the LADA Act.
Correct.
Right?
Right.
So that assurance was there.
Yes. Now, when the assurance was there, can they back out?
Now, that is the question.
That's the question. Can they back out? And not only back out, my lord, with great respect. My lord, I was shocked that when the writ petition was filed. Well, how can, my lord, a writ petition can be filed, my lord? That is, I am asking myself, my lord. My lord, I have gone through the entire writ petition. I have taken a point on maintainability. It is doctrine of, barred by doctrine of res judicata and principle of estoppel. I have seen state has also filed an application that this writ petition is not maintainable. And my lord, they have come with an unclean hands. They have suppressed certain documents before the court in the writ petition, my lord.
Okay. We'll hear you on the writ petition.
Yes.
After the argument of the petitioner.
Yes. My lord, only one chance. So I am deeply obliged for giving such much of opportunity to us. Only the judgment which you have cited, 5 minutes tomorrow, I will just explain this is not attracted in the present case. All the judgments,
Tomorrow.
which my learned friend has cited.
Tomorrow.
When your lordship is fixing today itself, hearing?
No, on which that the other side is ready to argue the matter.
Yes.
My
Because
lords,
your lordship,
we are requesting for a short date, my lords. We have to file a rejoinder affidavit in the writ petition, my lords.
maintainability point.
For a short date, my lords, what we are requesting that the contempt petition may be decided, my lords.
No,
Contempt petition has been heard, my lords. There are just 2 points. I will just highlight those 2 points. And the
No,
contempt may be finally
This is
decided,
what
my
we
lords,
want.
because the cause
No,
of
no,
action.
Mr. Nair.
Please, my
Mr.
lords.
Nair,
Please, my lords.
we will dispose of all the matters
Yes.
by a common judgment and order.
Correct. Right.
My lords, the contempt, it is our submission, my lords, subject to what my lords say. My lords, the
Okay.
contempt has a different cause of action and the writ petition has a
Maybe
different cause of action.
may not be by same judgment or order.
Please, my
Maybe a different judgment of order.
Please, my lords.
But on the same day.
So, my lords, may kindly grant us some date for writ petition, my lords. After 2 weeks, my lords, we need to file a rejoinder affidavit. My lords.
No, Mr. Nair, you see, the court will
May
remain
I
closed.
just, my lords, may I just inform my lords, the contempt petitioner here, my lords, are not the project affected families, my lords. The project affected families whose lands have been taken for the project, my lords, they have been compensated, my lords. The land for land allotment, the need that for that would arise only after 5 to 6 years, my lords, when submergence happens, my lords. The contempt petitioners here are those people whose land have been sought to be acquired for the purpose of resettlement of the project affected families, my lords.
Yes.
So today there is no urgent need of that land, my lords. The contempt petitioner cannot project themselves as PAFs, my lords. In fact, in the writ petition, it is our case that this is a case of state largesse because the land on the first occasion has to be identified from the state land bank. If it is not identified from, if there is a positive finding that the state does not have any land to resettle the project affected families, only then private land can be taken. My lords, the second point in the writ petition, we will argue that separately, my lords. But my lords, may kindly have the writ petition separately and the contempt petition separately. My lords, we have argued the point.
Okay,
far as
but
so far as
we'll
contempt
dispose
is
of the same on the same day.
Very well, my lords. As it pleases to my lords. First, I don't want to wish to place a sub rejoinder, my lords, but I will
Okay.
file a short note so far as the points which have been argued in the rejoinder. One thing,
Okay.
my lords, may kindly keep in mind, my lords, there is no argument related to the statement recorded on 6th of November 2025, my lords. Not even a whisper. The contempt petitioner's statement was recorded that award has been complied with. 8 months after that, the application is filed for the purpose of deposit and grant, which is not within the scope of the contempt petition, my lords. And my lords, for one proposition, my lords, a lot of this has been made on the undertaking, my lords. My lords, may kindly have my first note dated 25th of March 2026, my lords. Now, my lords, this is a land acquisition award, my lords.
Yes.
An award is a mandate of law, my lords, under the 2013 Act, my lords. It is not a matter of consent, my lords. Consent award has been passed. I am statutorily mandated to pay the compensation. Period. That the award has been passed within the four corners of the 2013 Act, my lords. If there is a grievance, my lords, then award, passing of the award gives a fresh cause of action to the contempt alleged contemners to file a challenge to that particular award, my lords. In the way of a contempt petition, NHPC cannot be precluded or can be restrained from taking its legal recourse in challenging that award, my lords. My lords, I am today what I am saying.
Okay,
If-
that's all right.
If the
Okay.
awards hold the judicial scrutiny of this honorable court as well as of the honorable apex court, my lords, then we are statutorily bound, my lords. It is not a matter of consent, my lords. Nobody can say that I consent to a payment under an award, my lords. It's a statutory liability. I have to pay it. It's a direction, it's an obligation under the statute. But what statute also prescribes, it gives me liberty to challenge the award subject to the condition that the award is not legal or within the four corners of 2013 Act, my lords. That right I have. Once that right has been exhausted, of course the payment has to be paid. If tomorrow a court sets aside this order, then whether I can be made liable to for the payment only on the basis of the consent. Well, for a statutory order, there is no consent required, my lords. May kindly have page 4 of my note, and I have addressed the point, my lords. My lords, para 17, Roman 3, my lords.
Yes.
Payment of compensation under an LA award is a mandate of law and not a matter of consent. Para 17. The overarching argument of the contempt petitioner that the writ petition filed by NHPC is to overreach the judgment dated 10/2/2025 passed by this honorable court is misconceived and has no legal basis. It is respectfully submitted that the consent recorded in the judgment and the order dated 10/2/2025 was confined only to the issue relating to one, payment of compensation in terms of 2013 Act in substitution of the local act, which was the contention raised in the previous order, my lords. Second, inclusion of interest at the rate of 12% per annum. NHPC is statutorily obligated to pay the compensation awarded under an award passed as per the provision of 2013 Act, provided that the said award is in accordance with law. The term agreeable to pay recorded in the judgment dated 10/2/2025 is to be comprehended in that context, my lords. With consent, my lord, it cannot be that I don't consent to pay under an award. That cannot be an argument in law, my lords. If there is an award, I am obligated to pay under the law. It can never be a matter of consent. It's a matter of mandate of law, my lords. But I have a right to challenge an award, my lords. That right is always there, my lords. I cannot be precluded, I cannot be restrained, stopped from exercising my rights, my lords. My lords, para 21. The said term agreeable to pay, which is projected as consent of NHPC, do not in any manner extend to or include any agreement for immediate payment or disbursement of compensation amount as determined fresh award, which is contrary to 2020. The horse that, my lords, no direction of this regard was issued in the order dated 10/2/2025, my lords. If the award dated 1/8/2025 stands a judicial scrutiny of this honorable court, then no direction or consent for disbursement of the same is required. My lords, I am obligated under the law. But what today, I am only exercising my right to challenge the award on the ground that it is not as
Okay,
per.
okay, that's all right, but when you are ready to argue the matter.
Yes.
My lords, may kindly have it after 2 weeks, my lords.
My lord, can I suggest one thing? My lord, I have raised the point of maintainability. The writ petition is not maintainable. So my, with your lordship permission, my maintainability, it is not maintainable, it should be heard first. If your lordship feel that it is maintainable, we'll get scope of filing a rejoinder. Please, Raju, I'm just requesting the court, please.
No, I am also
Mr. Nair,
requesting
my
may I just say
prayer before this court, let me first place before this court that writ petition is not maintainable. Your lordship feel the writ petition is maintainable, then your lordship of course gives a time for rejoinder. There is absolutely no problem. I am saying on the threshold of it that writ petition is not maintainable. And I am asking one thing. My learned friend is all that time saying that yes, we are going to pay. I am asking one question. When it was assessed whether the board repentive was present or not. Let my learned friend say before the 1 second. I am giving an answer to it. He is avoiding. While my lord, it was assessed, then board representative was present. Today they are making a different stand altogether. No, we are challenging. They have signed the award, my lord. Your lordship will see, call the records. Call the records of the government record is there, my lord. They have signed the award. The award has been signed by them. So with your lordship's permission, my lord, maintainability, I can argue the matter tomorrow because maintainability, I have raised the writ petition. I think the government also have raised the point of maintainability.
I am requesting.
So, let me raise my, because normally when a writ petition is filed, other side has filed an application for maintainability. I should get a chance, my lord, subject to your.
Mr. Nair, please wait.
Please, my lords.
So with your lordship permission, is up to you. I am just requesting a humble request that if your lordship allows me to submit that this is not maintainable, then your lordship will hear him that this is the argument what I have advanced, what you want to say on this. Maintainability, they will file, thereafter they will file it, my lord. If it is not maintainable, end of matter. If it is maintainable, my lord, then my contempt also, everything will go, my lord. Everything will go if it is maintainable, my lord. Your lordship has rightly said that both has to be heard together. Maintainability, I am raising the point of maintainability, my lord. That's my objection, preliminary objection regarding maintainability of the writ petition. Writ petition is not maintainable. I have received the copy of the government. There also the same point they have taken, the maintainability point. So your lordship, if your lordship allows, subject to your lordship permission, tomorrow let me start my maintainability. He can take a note of it.
No, Mr. Das, you say, can we not consider it at the time of final hearing? Let them argue their matter.
Well, it's up to the court. I just make
it during final hearing, you can raise the question.
Yes, of course, my
Mr. Nair, you suggested that when, but Mr. Nair, you see, from 11 to 19 April, this court will remain closed on account of Bihu vacation.
Please, my lords.
So, can you argue the matter on 9th or 10th? Oh, sorry, 9th and 10th will also be closed.
9th, my lords, the first 3 weeks in the Honorable Supreme Court, a constitution bench is sitting. My lords, the learned ASG would be there in the constitution bench, my lords. So what I am requesting, my lords, I just have the dates of learned ASG, my lords. If it can be in the last, sir, my lords, may kindly give me a minute, my lords. When is he going? When is he going? 27 to 38 is there.
27th is available. 21st.
7th. 28th. Well, it's 27. Well, if it can be on 29th, my lords.
29th.
29th, my lords. By that
Yes.
time, we will also be ready with the entire pleadings, my lords. We can argue the matter
But
completely.
they should give the copy, advance copy to us.
Obviously,
It is
obviously,
not
my
that they
lords.
will start and they will.
Yes.
Obviously, my lords.
Before 3 days, they will give a copy
My
to
lords,
us.
we have to file a rejoinder, my lord. I think filing cannot be done without serving a copy, my lords.
Yes.
Okay. So, Mr. Das, any objection on fixing the matter on 29th?
It's okay, man. 29.
Okay. So we have concluded hearing in the contempt petition as well as in the IA.
Yes.
Heard
Please, my lord.
Two
Mr. D.
IAs.
Das, learned.
Two IAs.
Two IAs.
One, we are asking for direction to make the compensation money to pay the and their maintainability.
Okay. Heard Mr. D. Das, learned senior counsel, assisted by Mr. Idas, learned counsel for the petitioner in contempt petition number so and so. And IA number
IA number
304.
304 is the maintainability and
Okay.
320
IA
is the
number-
IA for direction.
IA number 320 AP of 2025 and also on the IA number 304 AP of 2025. 2025. And Mr. Raju, learned
Yes, Raju, my lords.
additional Solicitor General of India, assisted by Mr. R. Nair,
Rajat Nair, my lords. And
Rajat Nair, and also heard Mr. N. Rotan, learned additional Advocate General for the state of Arunachal
Respondent.
Pradesh. Yes, argument concluded in contempt petition and also in both the IAs. Recess shall list the matter on 29th of April for hearing in for hearing of WBC number 58 AP 2026. Okay.
my lord, just
Mr.
one.
Nair also submits that he will file one rejoinder affidavit. Rejoinder affidavit, and he tries for granting him liberty. Liberty is accordingly granted. However, he is directed to furnish a copy of the same well in advance to the learned counsel for the respondent.
Please, my lord.
This should be hard and part.
One indulgence, my lord.
Part hard, man.
Okay.
One
Rest
indulgence,
shall list the matter as parted.
Yes.
my lord, one indulgence. My lord,
Yes.
there are two notes which learned ASG has filed. Note dated 25/3/2026 and
Yeah.
1/2026. That may be taken on record, my lords. My lords, may
Yeah,
record-
yeah.
my lords may record that in the order.
The note furnished by learned additional Solicitor General of India notes shall be taken on record.
My
Shall be
lords,
taken
it
on
is
record.
dated 25/3/26 and 1/4/26.
Yes. Yes. Okay.
We'll give a written submission by end. NDM. If written submission is given, my friend Nair should give it to us also, written submission in advance. Written submission.
Certainly, I think the copy has been supplied. The hard copy has been supplied of the two notes which have been filed. My lords, we are extremely grateful for the patient hearing, my lords. Extremely
Okay.
grateful.
Okay. Okay.
Yes.
Obliged, my lords. Obliged.